Welcome back. We're back. Thank you so much for coming back for the afternoon session of day 2 of the Ashley Benefield trial out of Manatee County, Florida. Courthouse is in Bradenton, Florida. Today is Wednesday, July 24th, 2024. And do you know where your children are? Do you know where your children are? That was kind of wild this morning, huh? I can't wait for Stephanie Murphy, the attorney for Doug Benefield, to get back on the stand to see what bombshells defense attorney Neil Taylor might have to drop on us, because that was some interesting testimony, some interesting demeanor of the witness. And it was a little bit odd to me. Yeah, this trial does have some spice. I didn't realize it was going to be like this when I started covering it. And it's got a lot more spice, Melinda, than we could have imagined, I think. Kristen says, if and when the state shows us evidence, we can decide then. I think it's like I'm walking into a conversation that I wasn't part of from the beginning. A trucker sale says that the music always makes me think of Charlie Brown. You know what it reminds me of? It's like Zydeco. It reminds me of Little Feat. Love Little Feat. And that's what it reminded me of. And there's certain music that YouTube lets you use for a small fee. And so when I was going through all of the music, that one just spoke to me, sang to me.
Between 12:30 and 12:35 in the afternoon.
I mean, they're talking, but there's no camera up.
Back from an early lunch break that I gave for the attorneys to do some research on an impeachment issue that had arisen during the cross-examination of Stephanie Murphy. Before we get to that, over the lunch break, I was in my office doing research, as I'm sure you all were. I was notified by a deputy that an unidentified female had come to the lobby of the 9th floor of the Judicial Center, had said that she is a reporter and she had information about the case.
What? Hold on.
And that she wanted to meet with me.
There was a reporter that came in and said she wanted to meet with the judge about the case. Hold on, we need to move over to Law and Crime because they have the camera up. So, wow, hang on a second. Some interesting spicier stuff came up over the lunch break when a reporter approached the judge. Hold on.
Is in state of Florida versus Ashley Benefield. It is Wednesday, July 24th. It's about between 12:30 and 12:35 in the afternoon. We're back from an early lunch break that I gave for the attorneys to do some research on an impeachment issue that had arisen during the cross-examination of Stephanie Murphy. Before we get to that, over the lunch break, I was in my office doing research, as I'm sure you all were. I was notified by a deputy that an unidentified female had come to the lobby of the 9th floor of the Judicial Center, had said that she is a reporter and she had information about the case and that she wanted to meet with me. And my judicial assistant, if I wanted somebody in the room. My response to the deputy was that I can't meet with anyone, but that if there was information to share, we were starting court at 12:30, that she should come to the courtroom and identify herself to the deputies as the person who wanted to speak with the court, and I would hear what she had to say in open court.
Wow.
A couple of minutes later, the judicial assistant that is filling in for my usual judicial assistant came into my office and said that the deputy had called her by phone and said that the unidentified woman had said she would not appear at 12:30, and that was it. So I'm just making a disclosure of extrajudicial matters that happen. I can give you a minute if you'd like to talk with your client and your respective co-counsel.
I would certainly like to know what it was she had to say, and I would invite her to contact me. I would make a determination whether or not it was something that I thought was worthy of being brought to the court's attention and to the prosecutor's attention. That's all we can do.
State, you want to be heard?
No, thank you.
Okay. All right, then let's finish up this impeachment argument.
Wow.
And we'll get the jury. At this point, I've asked for the jury to remain downstairs in the jury assembly room. Just it's more comfortable. The chairs are more comfortable. They can spread out. They have vending machines and so forth. So, all right, it's your objection.
And specifically, I am objecting to the manner in which the defense is trying to impeach this witness. I just want to frame the issue. This witness's character or bias based on what we spoke about before. First of all, I would say character is never appropriate for impeachment. I do have case law on point, but I think it's pretty clear that the only evidence of character that is allowed for truthfulness is reputation. And specific acts of untruthfulness are not allowed. So character, I do not believe, I don't know if the word was just used interchangeably, but I do not believe character has any part of this, and attacking character is not allowed. As to bias, I do not understand how what the defense is trying to do would achieve any bias. No ethical obligation or ethical complaint was ever filed. Even if one was filed, I don't know that that would be allowed to come in this case in this manner. I found no case law to say that that type of information could come in. But I also have objections to the manner in which this is trying to be done because, number one, Stephanie Murphy testified that the original petition for injunction had allegations in it, X, Y, and Z. Later, the defendant filed for, I think it was divorce, and alleged X, Y, and Z. I think what the defense is trying to say is that this attorney denied that allegation that was alleged in this petition after this attorney had been at Doug Benefield's deposition, implying that Stephanie Murphy knew different, but yet she still denied that paragraph of the petition. I have so many objections to that, but mainly I think even if that type of thing were allowed, this is like a motion to dismiss in criminal court where you admit a paragraph, you deny a paragraph. It sounded like she said that paragraph, number 5, was 7 pages. So I can't imagine anyone agreeing to a 7-page recitation from the other side. So I do not think it stands for what the defense is purporting that it stands for. But even if it did, I do not think it's appropriate for impeachment.
Defense?
Okay, so here's what we know. And by the way, if I use the word character in referring to this, I was mistaken and I meant to say credibility. Here's what we know regarding Stephanie Murphy's testimony. She acknowledged that Ms. Benefield filed this domestic violence injunction petition, and she specifically mentioned a couple of the allegations. Court may recall, in particular, shooting the gun in the kitchen into the ceiling, punching the dog, and potentially suspecting that she was being poisoned. So that the court appreciates my position, the fact that she mentioned 3 My position is it opens up the entire petition. She doesn't get to limit it to just the three she chose to mention on her direct because the state called her, they opened that door. It's before the jury, I'm entitled to rebut it and probe it for credibility and bias. Now, with respect to what Ms. Murphy did or failed to do, she comes before the jury and announces herself as an attorney and that she's representing Douglas Benefield. She then responds to Ms. Benefield's petition where these things are alleged, this inappropriate conduct, abusive conduct, if you will. And she denies that paragraph in Ms. Benefield's pleading, specifically paragraph 5, that Judge White lists all the horribles, the domestic violence horribles. So it's our position, and so that we're clear as to how I perceive this should unfold, she then never corrects the record, regardless of whether it's a violation of the code of conduct, which I do think is impeachable, to show bias and favoritism, and to show failure to act within her expected realm of conduct. But in addition, 27 days later, she is present at the deposition of her client where he admits to all of these: shooting the gun, punching the dog, knocking the dog unconscious, punching holes in the wall, throwing a loaded firearm, I believe perhaps putting a tracker on a car, whatever it is, he admits to it. I am entitled to ask her why, in light of that, she never advised the trial court that her client admitted to this conduct and why she didn't bring that to the trial court's attention. She never did. So it's not that I am particularly determined to show that she violated the code of conduct, which again, I do think I should be entitled to ask, but merely to show that the trial judge, I will ask you this question also, the trial judge wasn't at the deposition. So the trial judge never knew about these admissions. Now keep in mind, this is what she's presented to this jury. I am trying to rebut that. I am at least trying to cast doubt on that witness's credibility. I have two cases in particular in an effort to respond directly to Your Honor's request. No, I could not find a case where a lawyer was called as a witness, and based upon cross-examination of the lawyer who failed to follow a particular code of conduct, impeachment was allowed. What I do have, however, is typical scope of cross-examination as it relates to professionals and as it relates to lay people. I want to mention the cases to the court, and then I'd like to read what I think is the relevant section. So the first one is Mendez versus State. It's a second DCA opinion. It's dated April 21st, 1982. They say in this case,
Citation, not the citation.
page number is...
No, the whole citation.
Oh, so the whole citation is 412 Southern 2nd, 965.
Thank you.
The court says in this particular paragraph, cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test a witness's perceptions and memory, and to impeach that witness. And they cite United States versus Williams, federal case, Judge White at 592, Fed 2nd, 1277, 5th Circuit, 1979. limiting the scope of cross-examination in a manner which keeps from the jury relevant and important facts bearing on the trustworthiness of crucial prosecution testimony is improper, especially where the cross-examination is directed at a key prosecution witness. More important, and they string cite a bunch of cases to justify that, more important, a defendant should be afforded wide latitude to demonstrate bias or a possible motive of the witness to testify as she has. That's the Mendez case. And in that instance, the witness was a layperson. It was an appeal of the conviction for attempted second-degree murder of a police officer. The court reversed the conviction based on what I just read, Your Honor. I also have, Your Honor, Roosevelt versus State. It's at 42nd Southern 3rd, 293. It's a 3rd District Court of Appeal decision. It's dated August 4th, 2010, Your Honor. This was a conviction for a sexually violent predator and commitment under the Jimmy Rice Act. It was reversed. It was reversed based upon the main question on appeal is whether the trial court erred in allowing the state to impeach the defense expert witness, Dr. Natalie Brown, concerning 3 separate matters. So in Roosevelt, it was a professional witness. She was a psychologist. The state was allowed to cross-examine the expert about an email that she sent while serving as a defense expert several years previously in a Florida criminal case. The state argued this testimony showed the expert's willingness to tailor her testimony to favor the party who had retained her and was therefore admissible to show bias. Here's what the court stated. Our evidence code liberally permits the introduction of evidence to show the bias or motive of a witness. Included within the types of matters that demonstrate bias are those that relate to the interest of the witness, favoritism, and corruption. Dr. Vicari's willingness to forge her interview notes at the request of the defense attorney could illustrate Dr. Vicari's corruption as a mental health expert. Therefore, because this line of impeachment could properly relate to the witness's bias, we find that the trial court did not abuse its discretion in permitting it. The last case I have to cite for the court is Russ versus City of Jacksonville. It is at 734 Southern 2nd 508. It's the 1st District Court of Appeal, Judge White, and it was decided May 19th of 99. The court reversed and remanded the ruling for a new trial because the trial court committed an error when it denied the admissibility of information relating to the prior DUI arrest practices of the defendant's city's witness. So in this case, Your Honor, it was the impeachment of an officer. Turning to the merits of the appellant's argument, impeachment of evidence by the officer's prior acts. Turning to the merits of the appellant's arguments, the credibility, bias, or prejudice of witnesses who testify in a case, as well as the weight to be given their testimony, are a matter for the consideration of and determination by the jury. where the credibility and bias of an officer is brought into question by virtue of that officer's past acts, impeaching evidence of the officer's past acts is admissible. As the Second District Court of Appeal explained in Mendez versus State, which was the first case I cited to Your Honor, quote, whenever a witness takes the stand, he by that fact places his credibility in issue. Cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test the witness's perceptions and memory, and to impeach that witness. The right of full cross-examination is absolute, and the denial of that right may easily constitute reversible error.
Ooh, nobody
I'll be
wants
happy
reversible
to
error.
show you what the cases if you like.
I was familiar with Mendez and Russ. I'm well aware of those two cases. Those come up quite a bit. And Roosevelt, you've explained it. I'm happy to take them, but
Yeah.
it's up to you.
All right, so if the court's aware of it, I don't see any necessity if Your Honor wants it, it's here for the court. My opportunity of Sixth Amendment right that belongs to Ms. Benefield to cross-examine Stephanie Murphy is restricted when the court doesn't allow me to quote the story that she told here today. And that's going to include, respectfully, Your Honor, my then being able to ask Ms. Murphy, so I can try to save time here for the court and everybody else. In fact, did Douglas Benefield make these admissions at his deposition when you were present? And I propose to tick them off one by one. The reason for that is the court may recall that Ms. O'Donnell asked Stephanie Murphy what she observed, not only when they did the first exchange and how pleasant Doug Benefield was, but she concluded Ms. Murphy's testimony by having Ms. Murphy opine what a gentle, kind, and decent guy Douglas Benefield was.
Yep.
And I have previously given Your Honor a written memorandum establishing the case law that says questions such as, well, did you know, Ms. Murphy, that he admitted A, B, C, D? Yes, you knew it because you were present. Are proper questions on cross-examination. If the court disallows that, the court has abridged Ms. Benefield's right to cross-examination. And I might add, Judge White, in the interest of fundamental fairness, given her testimony, I should be able to ask her that.
State.
Judge, and I'm confused about exactly what's being impeached, so.
Okay. Well, I'll let you know, Miss Prosecutor, because apparently you weren't here for your own direct examination, during which time you questioned Stephanie Murphy, who was the attorney for Doug Benefield in the domestic violence restraining order petition, and also perhaps some custody and divorce issues. You said, and I quote, because I wrote it down, that you were with Doug Benefield for the exchange or time sharing, as you call it, for the first meeting of his daughter. You went with him apparently to the sheriff's office to do the exchange in the parking lot. And you said that Ashley gave you or him a nasty look, and that you thought it was, and that Ashley said to you, "Are you two dating?" And you said, "Of course not." And then you said that she then very strangely, Ashley offered to go with Doug for the visitation or the time sharing, as you like to call it, and that it was very, very strange that you thought that the two of them did that, and you were kind of taken aback by that. And you said that there were unfounded, horrendous allegations against Doug, and that you pulled him aside before he went with Ashley on the visitation, and you said to him, "This isn't good. She's trying to set you up." And then at another point in your testimony, you then went on to say that Doug was never overly angry. In your opinion, he was never angry. He was mellow. And in fact, I thought he was too easygoing. And that was a point of contention among us, which is very interesting testimony, considering that at his deposition, he testified that he punched the dog in the face so hard that the dog became unconscious. He shot a gun into the ceiling, that he threw a loaded gun at her, and some other things. So absolutely, I think this should come in as impeachment evidence, because this witness has opened the door to those things by talking about these horrendous allegations that were then admitted to during a deposition that she was present at. Okay. Since the prosecutors didn't seem to know what the defense was getting at, I was happy to help her. And you, who may not have been here this morning for that spicy testimony. Right. Dating? Of course not. Okay,
So
let's hear the
apparently,
prosecutor
Judge,
again. Feign
State,
misunderstanding.
Judge, and I'm confused about exactly what's being impeached. So apparently, what the defense is saying is that because Stephanie Murphy said during the time that I dealt with Doug, he never overly expressed anger towards Ashley. I guess that's a new one. So apparently that now opens the door to showing that she knew other things.
Uh-huh.
The question to her was, during the time that she was dealing with Doug and Ashley, what was his level of anger? Not what had happened before, not what she knew before. So I'm not sure that's how that opens the door when I asked her what the behavior was during the time that she dealt with Doug. So I'm not, and that's a whole different issue than all the case law we just talked about. I do obviously agree with the case law that you are allowed to impeach under the right circumstances, under the law, if the matter is relevant to credibility. I do not believe that any of this is relevant to the credibility of this witness. I believe that the defense is merely doing this for obvious reasons, trying to get in the admissions of Doug Benefield, which I dispute that he admitted things the way the defense characterizes them. So just by virtue of the fact that they're stated differently, I would disagree with their statements that he made. So I think that is what the defense is trying to do by labeling it as credibility and an attack on credibility. I think even if an attack on credibility was allowed under such circumstances, the specifics of these items would not come in. The fact that Ashley Benefield's petition for injunction listed 3 things does not open up Pandora's box where he can then impeach on the fact that the defendant admitted to those things.
You called her in.
The court has already ruled that the state can generally talk about what the complaints were, that they were denied, and that type of thing. That's what the state did, generally talked about what the complaints were, and then that it was denied by the judge. So that's what the state did. I don't know how that opens the door to this type of attack.
You kick the door.
all right, so I think from the first moment I had a hearing before you in this case, I have explained the procedures that I follow, whether it's a motion hearing, an objection, and that is the objecting party goes or the moving party goes, tell me everything you want to tell me. And then I go to the other party, the non-moving party, or the party in this situation that's the proponent, and I say, tell me every argument that's in favor of you, and then I go back for rebuttal. And the reason I follow that process, and I've been very clear, and I've always followed that process, is because otherwise it'll just be back and forth and back and forth and back and forth. At some point, I have to make a decision and move on. All right. In this particular situation, as with all cross-examination, multiple factors are at play for any particular witness for impeachment purposes on cross-examination. Their perception, where they were, what they could see, what they could hear. There's 5 senses. Their memory of that, their ability to recall, their ability to communicate, their bias, any motivations they may have to testify a certain way, prejudices they may have, interests they may have in the outcome or a particular ruling, prior inconsistent statements, prior convictions. There's another number of avenues. And that's explained further in the case law. I have not been provided a case on point for this particular scenario.
Because it doesn't
So
happen.
as Mr. Taylor has astutely pointed out, whatever ruling I make may very well be the subject of an appeal to the Second District Court of Appeal. They may find I did something wrong or let something in I shouldn't or kept something out I shouldn't. And that's just the nature of trial work, the nature of being a trial judge and making decisions on the fly. But I'll frame this one up as best I can so it's ready for the appellate court. I find that the current avenue of impeachment of Ms. Murphy is improper. I'm going to sustain the
Bad decision.
objection. I find that it is improper impeachment to attempt to get in the victim's statements made in a deposition in a civil case
It doesn't
unrelated
matter.
to the criminal case through the impeachment of his attorney in the civil case based on an allegation that she violated a rule of professional conduct by not amending her answer to his complaint when it is alleged that she subsequently became aware of
No, that's not it. She
contrary
testified that the
information.
allegations were unfounded. And that's the impeachment, that she knew they were not unfounded because he admitted to them under oath at a deposition. There's a transcript. She did open the door to that. I completely disagree. This could be a reversible error.
I find that it doesn't provide any basis for impeachment under the existing case law, and this may be the case that says it does.
Yeah, this
All right.
may make some law here.
So are we going to bring the jury back in?
Yeah.
Wow.
Before you bring them back in, just so I understand, so I'm precluded from basing my cross on the.
Okay, so I don't know if this was the Lisa that said this before, but if you're ahead in another stream, please do not spoil this for us with what happens, because we're watching it in real time and analyzing it, and we're usually a little bit behind because I do stop the stream. So if you're watching several different streams at once, please don't put spoilers in the chat. Thank you.
Failure to conform to the professional code of conduct. Am I likewise precluded from probing her statement that Doug was a gentle individual and that the complaint that was filed was unfounded? In fact, the quote played back, that was her characterization, that the allegations by Judge Morland were unfounded.
I sustained that objection. So, sustained. Are you ready to bring the jury back in?
Yes, but do we need the witness on the stand?
Yeah, I'm just asking right now,
Yeah.
are you ready?
Yes.
Are you ready?
Yeah, I would like to first make a motion. I move for a mistrial. I move
Moving
for a mistrial.
for a mistrial.
Based on the court's absolute and consistent denial of Ms. Benefield's right to cross-examine, and at every turn, the court's ruling adverse to the defense, despite the fact that the court has, under the same circumstances, allowed the state to be able to pursue it. I think individually, perhaps, it could be argued that they don't reach the level of reversible error, but I think cumulatively, especially given the state of mind that the court displayed in writing the order denying the standing your ground, where Your Honor fully stated that Ms. Benefield was guilty, I think we are seeing the result of that, and we are being denied not only the right to cross-examination, but the right to a fundamentally fair trial.
Would you like to be heard?
Yeah.
Denied. You ready to bring the jury in?
Yes.
You ready to bring the jury in?
Yes.
All right, can you have Ms. Murphy step back in, please?
Wow. Motion for mistrial denied. Motion to be able to impeach this witness, Ms. Murphy, based on the fact that, in my opinion, she opened the door to all of this stuff by saying the allegations were unfounded, that he was totally not violent, that it was a point of contention against that, between them. Just her whole weird testimony, which if you didn't watch, go back later to this morning's stream and watch this attorney's testimony. This is wild, and in my opinion, could be a reversible error on appeal, depending on which way the jury decides. But that was what he thought was well-reasoned ruling that I completely disagree with. In my opinion, she kicked the door in, kicked it in. The prosecution called her as a witness, and she liked to give narratives, and it's her fault for opening the door, and I completely disagree. But they did make a record.
I also need to ask, did anybody at all speak with you about your testimony or the questions asked? Did you speak with any of the attorneys? Did you speak with any of the witnesses about questions they were asked or the testimony they gave?
No, none of those.
And did you watch any of the proceedings?
God, no.
Pull me up.
Even Mike Nichols is heated, you guys. Look out. Mike's coming in hot. If you're tuning in late, the judge also indicated to us that a reporter showed up in the courthouse wanting to speak to him. And the judge said, okay, you need to do it in open court. Come back at 12:30. And this alleged reporter did not come back. But he did mention that when he took the bench before they started arguing about the impeachment issue that they both did research on during the break, and whether or not Stephanie Murphy opened the door with her testimony. So that was weird. Somebody showed up to the courthouse that said that they were a reporter and that they had some information about this case. They wanted to talk to the judge. And as soon as they were told it had to be done in open court, they disappeared. So I have questions about who that person was as well, but very strange. Weird stuff happening today. What is she doing? Oh, she's cleaning her glasses. Agreed. He did make a good record, Kim. I thought he made a good record.
All right, y'all can have a seat. Welcome back, everybody. Hope you beat the crowd for lunch. Did anybody discuss the case amongst yourselves with anybody outside of this group? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about?
No sound.
All right, everybody says no. When we broke for lunch, Mr. Taylor was cross-examining Ms. Murphy. You may resume your cross.
Thank you, Judge White. Ms. Murphy, we've pretty much established that the homicide occurred on September 27th of 2020, correct?
That's my understanding, yes.
Okay. And then you've told us here today that Dr. BROEDER's report was set to be released 3 days later on September 30th. Is that correct?
Yes.
All right. And the inference by you in the state's theory is...
Objection?
Ooh,
So I'm sorry, Judge, was that overruled?
overruled.
Thank you. The inference by you and by the state's theory is that Ms. Benefield then killed Mr. Benefield to stop the release of Dr. BROEDER's report.
Are you asking if that's what I believe or if that's what the state's inference is?
Well, you've discussed the matter with Ms. O'Donnell, have you not?
I have, yes. Yes, I have.
And in fact, she's provided you with all the documents in the case, hasn't she?
I don't know if she's provided me with everything, but I have gotten a lot of documents in the case.
By direct conversations with Ms. O'Donnell.
Yes, I did a
Okay.
discovery request.
And so is the implication not that, as you testified before the jury earlier, Ms. Benefield shot and killed Mr. Benefield because of this report that was coming out by Dr. BROEDER 3 days later?
Absolutely. I have no doubt.
Okay, so that's the theory of the homicide.
Right.
All right,
She has no doubt that that was the motive. She's very emphatic with her responses. Never, always, no doubt.
so I want to pass you some emails, see if you recognize them.
Oh, good.
Can we approach?
Yes.
Oh, they're approaching again. Can't wait to hear the emails. She knows how to smile at the jury. We do know that there are 9 people that have been selected. 6 will sit on the final jury because this is not a death penalty case in Florida. 7 women and 2 men make up the panel. And we do not know who the alternates are yet, but we have been told by our friend who was in court yesterday that most of the jurors are in their 60s, 70s, or 80s, and the youngest is a male in his 40s. And we don't know who the final jury is going to be. We don't know who the alternates are.
Just take a look. So I would like to pass these documents to you and let you just take a look. Take your time.
I'm going to switch us to court TV, so just hold on. How'd you like that seamless transition? I'm getting good at this technology, my friends. Agreed, Mary. Mary says, doesn't matter if you're the defendant and a random witness. No need to be smiling when there was a murder that happened. Or we'll call it a homicide for now. Oh, we're on real time. Look at us. Yes, lawyers make the worst witnesses, in my opinion. El Fliggins says, getting lawyers on the stand is always squirrely. We have some new members. Welcome to Fancy Drew and to Sue's Blue Sky. You're going to like it here. And thanks, Lady in Boston, for gifting a membership. That's so very kind and generous of you.
Okay.
I saw people in other vitriolic chats saying that Ashley was making herself look, less beautiful than normal on purpose, that it was all intentional, that she's acting, that all, it was just, couldn't believe what was going on out there in the wild world of other chats where
I have a series of simple questions for you. Do you want to reconsider whether or not the release of Dr. BROEDER's report was set for 3 days following the incident?
It was agreed with,
Do you want to,
no, I'm not going to
Answer.
revisit that.
you can answer and then explain if you like. I'd like you to
oh, hold on. Let's move these closed captions for you.
first answer.
I'm not revisiting the answer. My answer is the same. It was set for the 30th, 3 days after.
Okay.
And I can explain further if you want to hear more.
No, that's fine. As long as you've reviewed that, it refreshed your recollection, I trust.
It does. I don't think it's a complete
Then don't.
conversations, but yes.
Is the volume better on Law and Crime? We might have to go back there. Hang on a second. I think it was better too. Hold on. Oh, she's getting testy. Hold on a second. Let's go back a little bit.
Yes,
Can you repeat the question?
I knew you were going to ask me that.
Also stated, called
that
We're just
That's
rewinding.
correct. I think he was. It does. I don't think it's
Oh.
the answer. My answer is the same. It was set.
first
No,
All right, here we go.
following the incident.
it was agreed with.
Do you want to,
No, I'm not going to
Answer.
revisit that.
you can answer and then explain if you like. I'd like you to first answer.
Okay. I'm not revisiting the answer. My answer is the same. It was set for the 30th, 3 days after.
Okay.
And I can explain further if you want to hear more.
No, that's fine. As long as you've reviewed that, it refreshed your recollection, I trust?
It does. I don't think it's a complete conversations, but yes.
Okay. Now, is it not a fact that Dr. BROEDER on the 3 days following the event was on vacation?
What event? The murder?
Yes. The 3 days following the event that this report was to be released, is it not a fact that Dr. BROEDER wasn't in town? He was on vacation.
I don't think that's correct. I think he was on vacation the week prior, but I don't know. I try to remember everyone's vacation, but this was a lot of years ago.
Is that document in front of you contain emails between you and?
Objection. Relevance.
Oh,
Does that document that you were holding contain emails between you and Judge Morland's judicial assistant?
As well as other people.
But that's not what I asked you. I asked you, does that document contain emails between you and Judge Morland's judicial assistant?
Not only, but yes.
All right. And you still maintain, after reviewing that the hearing was set for release of Dr. BROEDER's report?
Dr. BROEDER was returning from his vacation on the 23rd. So if you look back
Not
through the emails.
not responsive to my question, Your Honor. She's editorializing. I asked her for a simple answer.
That's right.
She can feel free to explain it after if the court feels that's appropriate.
also stated, it called for a yes or no.
That's right.
Well, and that's why I'm saying she's, okay.
No, it called for a yes or no, so
Oh, okay.
your objection,
Is sustained. Got it. All right, so is the answer to my question yes?
Can you repeat the question?
I knew you were going to ask me that.
Well, I want to be accurate.
Can I ask the court reporter, Your Honor, to read the last question back?
And this, my friends, is the beauty of a court reporter that doesn't have voice recording, that has an actual steno machine, because that's what I do all the time. Can you please read the question back? Because I don't remember what my question was. He's already on to his next thing. We didn't have that in Karen Reed. They tried to cut the
Can you
budget.
still maintain
in
after
Norfolk.
reviewing that the hearing was set for release of Dr. BROEDER's report?
Yes.
Now, could we agree if Dr. BROEDER was out of town and not available, and the court would not entertain the hearing unless Dr. BROEDER was present, could we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly, because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. BROEDER was not available because he was on vacation. I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
And it's your testimony.
After your client killed my client. Boy, she just keeps, why is this so personal to her? She said kill about, I don't know, maybe that's the 10th time. I wish I had a counter for how many times she said your client killed my client or kill, kill, kill. Just giving me a weird vibe.
Then that the hearing would have taken place.
Had he been alive, yes. On the 30th, not the
Yes.
23rd, which is what I think you're
All right.
confusing.
Yeah, now she's telling him this
You
job.
referred to a letter that you sent to Miss Benefield on March 14th, 2018.
My memory is that it was the 15th of March, but if you have it, that would certainly help. And do you have the email that was sent with it?
No.
Okay, this is not the letter that I sent. This is a draft of a letter.
Mhm.
The letter that I sent on the 15th was on my letterhead, so this is not the letter.
Okay. The letter that you did send on the 15th, I think you told us, if I'm not mistaken, was an effort by you on Doug's behalf to advise Miss Benefield, among other things, that he wanted to try to work things out.
No, I don't think that's correct. No, that's not what I said this morning, nor was it the intention of the letter. And I don't have the actual letter I sent to verify, but there was nothing about reconciliation. The letter was about whether she would agree to him being present for the birth of his child,
Okay.
what was supposed to be the next month.
All right. So you sent the letter to see if she was willing to have him present for the birth of the child.
Yes, that's right.
We're in agreement.
Yes.
All right. Were you aware whether or not there was any prohibition at the time that you sent that letter from Douglas Benefield coming in contact with Ashley Benefield in any capacity?
I'm aware that there was an injunction that was entered by mutual agreements. It was what people refer to as a mutual restraining order out of South Carolina.
Correct. And it was in effect at that time, was it not?
It was. They would have had to
So
have a written agreement modifying that.
So that would have prohibited Mr. Benefield from being present with Miss Benefield, would it have not?
No, I don't have the South Carolina order in front of me, but my recollection.
do.
Oh, that would help if I could see it then.
I do. I've got it right here. There was an order of protection in South Carolina that was in full effect when she sent that letter asking for that he wanted permission to be present at the birth of his child. She played dumb, thinking he wouldn't have it. But as we know, Mr. Taylor shows up with receipts. He's going to backdoor this information in. I just have a feeling.
May I, Your Honor?
You may approach, yes.
Here's the transcript, here's the order. What is the date of the transcript?
Well, the date of the hearing was November 3rd, 2017.
November 3rd. And you were aware that the order was entered for a period of 6 months, correct?
I wanted to, didn't you hand this to me for me to look at?
Sure.
Okay.
Wow.
Okay, so what's the date that the hearing takes place?
The hearing took place on November 3rd, 2017.
And at that hearing, Doug was present.
It appears so, according to the order
All right.
that was entered
And
10
if
days
you-
later.
If you look at the last page, I believe paragraph 2, the judge orders.
I'm going to object to going through this hearsay piece of paper.
It's a hearsay piece of paper. It's a
Are we
court.
only talking
It's a court order. It's a court order. It's not a hearsay piece of paper. It's a legal document.
about the order?
Right now, she's looking at the transcript.
No, this is the order.
Okay, the order.
If it's a court order and you're asking the witness to interpret it, I think that's okay. I think she's demonstrated that she has
You.
sufficient experience, training, and knowledge.
All right. So the hearing concluded on the 3rd.
It appears that it did. You know, I wasn't there.
Yeah.
This was before my time.
But you were aware of that when you sent the letter to Miss Benefield. In other words, you knew you were sending the letter because Mr. Benefield was not allowed to communicate with Miss Benefield. Wasn't that why you sent the letter?
No, that's not why. Maybe that's why he didn't send her a letter, but that was not the reason why I sent the letter. I sent the letter so that it was a formal request, not in between the two of them directly.
Would you agree that had Douglas Benefield asked that of Miss Benefield, it would have been in violation of that order?
This is Spain.
She's a
Let me
family.
pass to you,
She can
if I can, this document.
Did you see it?
I did not. I don't know.
I need you to show it to opposing counsel before you show it to a witness.
I thought she had a copy. That you knew on Miss Murphy, is it not a fact that you knew on September 18th of 2000 that the only matter being heard 3 days later on September 20th was the injunction, not the release of Dr. Broeder's report?
Now, I think you're getting the dates confused again. So this was September 18th, was this email talking about the judge setting a hearing on September 23rd, because in this email, she did say the only matter being heard on September 30th is the injunction. That changed after this time. And you don't have those emails, apparently.
Do you?
Well, no, I don't have my file with me. It's 3 boxes worth of documents. But before we even went to mediation, it was agreed and the court was advised that we were going to be addressing only the joint motion for the release of psychological evaluation.
Objection.
Which was not said on that day, correct?
You mean the 23rd, which is what they're talking about in this email?
Yes.
Right, it was not said on the 23rd. Dr. Broeder was on vacation.
Okay.
It was going to be said on the 30th.
Did you know whether or not Doug Benefield sent a package to Miss Benefield in November of 2017?
I don't remember the date. I know that he did send her a package before this order was signed, but after the hearing took place in South Carolina.
Okay, so after the judge ordered no contact, he sent her a package.
My understanding is that Doug did not really understand what was going on at this hearing. I know Ms. Benefield was even chastised by the court for manipulating that.
Objection. Miss Benefield was even chastised. Keep going, honey. Keep opening the doors. Wow. Hold on. Doug didn't really understand what was going on at this hearing. Well, you didn't know anything about it before, but now you seem to know all about it. And he sent her a package after he was told to have no contact with her. So he's in violation of the order. When did he retain you? Hold on. I want to go back to my notes because I want to. She started representing him in March of 2018. So she's referring to something that happened in November 2017 when Ashley was pregnant, but the baby had not yet been born because the baby was born in March of 2018 because that's why she was retained to write the letter, to be present at the birth. And now she's going to testify about what Doug understood and didn't understand from that November hearing. Okay. Doug was no stranger to litigation. Doug had been sued before for allegedly swindling investors out of money. Doug had retainers probably all over the place and attorneys. So I don't really think that he didn't really understand. I'm sure he didn't show up to this hearing unrepresented in South Carolina. He just didn't hire you because you're admitted in Florida and he needed a South Carolina lawyer for that. So let's take this back a second.
My understanding is that Doug did not really understand what was going on at this hearing. I know Ms. Benefield was even chastised by the court for manipulating that system.
Wow.
Thank you for adding that. Let me just ask you a question.
So we're adding that.
What is it about you may not contact Ms. Benefield that you think Doug didn't understand. By the way, Doug was there and heard the judge say it, so enlighten us, please. What do you think it was about you may not contact Ms. Benefield that Doug would not have understood?
Doug did not have the court order when he went to buy her birthday present. He told me that the negotiations about this mutual restraining order took place in the hallway outside of the courtroom. But I wasn't there, so that's just what I was told. And we had the time that he received this order from the judge, from his attorney's office, and it was after he sent the package.
So now he's love bombing her with gifts with a birthday present that he felt he had to buy her after a no contact order. And she's still defending him. He's dead and she's still defending him. What is her like real personal motivation here to show up and give such opinionated testimony?
Okay, so this report by BROEDER, the one that you acknowledge and the state suggests is the theory behind the homicide, Ms. Benefield had signed a voluntary agreement to participate in that evaluation, correct? It was not court ordered. Isn't that what you told us?
It was not court ordered in the
Okay.
family law court.
So
I don't
she
know what she signed.
She voluntarily participated.
You know, I don't know. You're going to have to talk to the Manatee County Sheriff's Office because it came out of that office or the CPT office.
Well, you were the lawyer for Mr. Benefield. Was your client ordered to participate?
I don't know that we're in agreement with the word ordered. So when I think of an order, I think that a judge has ordered people to do something. And so we had filed a motion for a psychological evaluation in the family law court. And so if that judge had signed the order, that would have been an order. So my answer is I don't know if either of them were ordered to participate.
You're not aware of any commandment that either Mr. Benefield or Ms. Benefield participate in Dr. Broeder's evaluation.
It's my understanding that they were both required to as part of the investigation with the Manatee County Sheriff's Department.
I thought she was going to say CPS.
Give me just a minute, Your Honor.
Yes, sir.
Wow. So that is their AV squad guy. He's also their paralegal. And they made a motion pre-trial to say, can he sit at our table? The judge said no. They had to fight for him to get that little table back there.
Please.
Let's just stop to hit the like button, everyone, shall we? Thank you so much. It helps the algorithm. The rustling of the papers. I have earbuds in, or headphones in, and the rustling of the papers is really getting to me. Hopefully you don't have earbuds in and you don't have to hear it as loudly as I do, but it's nothing we can do. It's a pool camera inside the courtroom, and we get what we get, and we don't get upset. Kind of like they teach you in preschool.
Can I see the document?
Yes. Document have.
Okay.
Does that document have any impact on your position that the release of Dr. Broeder's report was scheduled for September 30th?
It was scheduled for September 30th. We knew before the weekend that the hearing on the 30th was going to address the joint motion to release the psychological evaluations. Ms. Brown and I had extensive discussions about that because Ms. Benefield was agreeing to dismiss her petition.
Ms. Murphy, I'm sorry to cut you off. Is the answer to my question no, that it doesn't change your position?
It does not change my position. It was scheduled for the 30th.
Well, when we say scheduled for the 30th, is it not a fact that the only hearing that was to take place on the 30th was everything other than Dr. Broeder's report?
If you
Is
had,
the answer to Michael, let's get a simple answer. Is the answer to that yes?
I don't have the docket. So I guess the answer is I don't know what the docket says. All I know is
You
it was
did not
scheduled for
know.
the 30th.
Objection, Judge Leonard, answer the question.
You trying to make
That's your
this,
answer.
All I know is that that was supposed to be addressed on the 30th of September.
and were you not told on the 30th September that the only issue that would be heard was the
Objection,
domestic,
asked and answered.
Ooh,
was the domestic violence injunction? That's what I'm asking you. Is the answer to that yes or no?
Initially, that was what we were told. That was not the case by the time we got to mediation. The situation had changed.
Yeah. And do you have any documents that you brought here today to support your contention and the state's theory that the release of this report was the incentive for Miss Benefield to kill Douglas Benefield? Do you have any documents that show that that correspondence with the court's judicial assistant was wrong and that-
Objection, compound question?
and that the only matter being heard was
Objection,
not
compound
let me
question?
finish.
the domestic violence injunction?
Sustained.
Okay,
Do you
break
have
it down.
anything that supports that the release of Dr. Broeder's report was scheduled for the 30th?
I don't know what documents you got from Ms. O'Donnell's office. However, I did provide
Do you
emails.
have any documents here today?
I didn't bring anything, nor was I asked to.
Okay,
You should
so
have
you
the
knew,
emails.
wait, you knew you were coming to court to testify before the jury in a homicide case.
Objection, badgering.
A murder case.
Go ahead and answer your question.
It's not
That
badgering.
the incentive for Miss Benefield to kill her husband was the release of this report on the 30th. You don't have anything to support that other than what you've told us?
Sustained.
That's all.
Don't, sir, you have one more paper. Mr. Taylor, don't forget your paper.
Judge, the jury heard it.
After the witnesses.
All right, redirect.
No questions, thank you.
Can this witness be released?
Yes.
Absolutely not. She's under our subpoena.
All right.
Absolutely not.
Remain under subpoena. As I said before, same rules on,
You're still under subpoena, ma'am. So perhaps, counselor, you should go back to your office and find some documents to support your theory that you said absolutely you had no doubt that the reason that Ashley killed Doug was because this psychological evaluation was supposed to be released on the 30th. That's what she said earlier, if you missed it. She said that absolutely, it was her 100% opinion. She has no doubt that that is why Ashley killed Doug, because that psychological evaluation for both of them made by Dr. Broeder was going to be released 3 days later on September 30th.
have a seat.
There was a valid order of protection on him when he sent her that package in November of 2017 for her birthday.
Subpoenas for depositions and trials in the old days had to be procured from the clerk, which is obviously a branch of the court. That was changed many, many years ago to allow attorneys to save time and effort and money for everyone involved, where attorneys of record were granted the authority under the Florida Rules of Criminal Procedure to issue subpoenas for deposition and trial. I would imagine if we pull them up, and I'd be happy to take a look at it, I would imagine that the subpoena that was issued is for the court.
I would have to look at this.
My position is when a witness is subpoenaed to court, and the reason I ask each and every time can this witness be released? Because I believe witnesses are subpoenaed by the attorneys on behalf of the court. So whether you were subpoenaed by the state or the defense is of no moment to me. I asked, could you be released from a subpoena? The state said yes. The defense says no. That's all I need. So, Ms. Murphy, you are not released from your subpoena.
Thank
The obligations regarding the rule of sequestration in Florida statutes applies to you. Thank you.
Thank you.
So don't go on court TV again like you allegedly did this morning with cousin Tommy. I think so. I think she cannot go on court TV. She's still under subpoena. She's still under oath, technically. She should not be talking about this case, but boy, did she smile at the jury.
All right, the witness has been excused. Mr. Taylor, you wanted to approach, but the jury's out, so I figured might as well just take care of it now.
Sure. So now I would ask that the court issue a subpoena to Judge Morland's clerk. The court may recall that we had an in-camera hearing where the court quashed the defense subpoena to Judge Morland's JA and told me that there were better ways that I could prove my case and that the court shudders to think what would happen if every JA were subpoenaed. What the court's just witnessed is Ms. Murphy lied flat out about the reason why Ms. Benefield feared release of that report, and my impeachment of Ms. Murphy indisputably is going to come from Judge Morland's JA, who told Ms. Murphy in the emails that I handed her and showed her the only thing that is set for hearing on September 30th, 2020 is the domestic violence injunction. Nothing else will be heard. In fact, I'm going to read for the record. I'm going to read the one sentence email that was sent.
The reason I'm going to stop you at this point is you're referencing arguments that were made in camera. The state was not present at your request in order to preserve trial strategy of the defense.
Yes.
Present at that hearing, when we stepped back into the jury room, was myself, a court reporter, Mary Ann Floyd, the general counsel for the 12th Judicial Circuit, Mr. Taylor, and Ms. Benefield. The state was not present. They didn't have an opportunity to be heard or know these issues. Now, the issues are being brought to light. In order for them to have a fair opportunity to understand the issues and be prepared to argue against whatever motions the defense may make, I certainly think due process requires they're entitled to notice and opportunity. I would do the same for the defense if there was some issue for whatever reason that I had considered in camera or ex parte for the state, and whatever reason the need for the privilege or confidentiality no longer existed, prior to having a hearing on that issue and requiring the defense to respond to it, I certainly think at a minimum, notice of the issue and an opportunity to be heard. So right now, they don't even have a copy of the order that I signed that you just quoted from, Mr. Taylor, and they have no idea what you're talking about because they've not seen that order because I ordered it to be sealed.
Yes, if the court will allow me, I'll elaborate. And I would like to read the email in particular.
The issue that you seek to have heard right now, I am happy to hear it. However, it is not a pressing matter. You seek to have a witness subpoenaed in order to present, I would assume, during your case in chief.
Yes, sir.
We could certainly address that issue at the end of the day after the state has had a chance to review that order. And I don't recall if the motion. No, the motion itself was public, but then we had the in-camera hearing and my order was, I sealed it.
Yes, sir.
So,
We had the email chain also as an exhibit.
yes, so the email chain is an exhibit. There were two exhibits, actually. I can't remember what the other one was. And then we had my order. So I'm gonna need to unseal those things so you have, you can get copies of them.
Okay.
I remember what the other one was. It was her prior testimony from the stand your ground hearing.
It was excerpts from the stand your ground hearing, excerpts of Miss Murphy's testimony. That was exhibit 2.
Correct, saying what she said today.
Okay,
So the only thing, if I may, that I want to supplement today's record with is I showed Ms. Murphy an email dated September 18th of 2020 at 10:18 a.m. included between her and the judicial assistant for Judge Morland. And it says as follows: "Good morning, Ms. Murphy and Ms. Brown. Per the judge, she will not sign an ex parte order for release of psychological evaluation and report. The judge will allow an expedited hearing on this motion. I have available Wednesday, September 23rd at 9 a.m. for 30 minutes. However, besides both attorneys being present, the judge has stated that Dr. BROEDER and Manatee Children's Services must be present at the hearing as well. Further, Ms. Murphy, the judge stated that absent showing where the court granted permission for the other motions stated in your September 17th letter to her, the only matter being heard on September 30th is the injunction hearing."
There you go.
and that is part of the email string that's one of the exhibits.
Yes.
All right, so like I said, I don't think it's appropriate to
And that's what Ms. Murphy, Counselor Murphy, refused to admit on the stand, that it was in that email from the judicial assistant that the only thing that is going to be heard on September 30th is the restraining order. And so pre-trial in one of the motions, and I don't think it was a motion in Lemonade because I didn't watch Lemonade, as we like to say, there was a subpoena. Neil Taylor subpoenaed the judicial assistant for that Judge Morland, or Morland, I'm not sure how it's spelled, to come to testify at trial. And the judge quashed that subpoena and said, no, you can't subpoena a judicial assistant because that's ridiculous. Then everybody would subpoena every judicial assistant and they're, immune from a subpoena. But now Mr. Taylor is making the argument that, hey, based on Murphy's testimony today, you have to allow me to let this judicial assistant come in here and testify under subpoena about what exactly was going to be released on the 30th of September, because that's their whole motive. That's the state's whole motive here, is that that's the reason that she killed him. And he's saying Murphy lied on the stand, and now I need you to agree to let the judicial assistant testify. Judge said we did that in camera. State wasn't a party to that. So we need to give them an opportunity to respond, and that's the right decision.
to hear this right now. I think the state has every opportunity and should be allowed to review my order and the 2 exhibits.
Just, can I just be heard real quick?
I'm sorry?
Can I just be heard briefly on
Of
something?
course.
Now, or you want me to wait?
Go ahead.
Okay. I don't know if, because I'm unsure what Your Honor is referring to, because we haven't seen it, the seal. I don't know that any of the things that Mr. Taylor just showed to Ms. Murphy were ever provided to the state in discovery, which is one issue. We received a defendant's exhibit list that was unnumbered and in no particular order. It has 391 items on it. I spent more time than I should have trying to organize it in some fashion, and I do not believe that any of those emails were ever provided to the state in discovery.
Wrong.
If they were,
He said
I'm still
wrong.
speaking, sir. If they were, I would just ask if somebody could give me the name, because I numbered them, but it has 391 items on it, and it's some of them have multiple things inside them, and they're not named anything that you can understand. So I'm just asking that if in fact they were provided, if we could, the items that were shown to Ms. Murphy, in addition to what Your Honor has said, he's unsealed, please.
All right, I'll let you 2 work on that, and I will look forward to having a Richardson hearing at the same time that we have the hearing on the defense request for me to reconsider my order quashing the mechanic trial subpoena.
I think mechanic is the judicial assistant's name. Hi, Jules. We're a little bit behind here on the stream, but do you want to email me the questions? Thank you, Black Rose. Crinkling of the papers. Stop. Make it stop. We're a little bit behind. Not by much. And the judge is right. They do have some time, not a lot of time, though, because the prosecution initially said they may be done with their case tomorrow. So today's only, what, Wednesday? We're only on day 2 of this trial, and there's been so much happening here, so much more than I thought. Very few breaks. They work full days. They start at 9 a.m. It's incredible what a difference a county makes on a state. Because the last trial we watched together was the Karen Reed trial out of Norfolk County, Massachusetts. And that went on for going on 10 weeks. Days off in the middle, half days. It was such a weird schedule.
I just prepared and sent to the clerk an order unsealing the prior order quashing Vicky Mechanic's trial subpoena, unsealing the 2 exhibits that were admitted by the defendant during the in-camera hearing, and unsealing the notes and transcripts of the court reporter that was present for the in-camera hearing. I'll sign that right now. Should happen pretty quickly, and state you'll be able to get copies of that, and we'll see if we can have this argument by the end of today or first thing tomorrow before we get started. On the defendant's request, or a tennis motion to reconsider order quashing, and the state's Richardson hearing. Would you, or I can state the evidence. Yeah, do 5.
NBM Esquire says, so impressive that Taylor got denied twice and still got what he wanted in the end. Bravo, sir. We were keeping the faith. As George Michael would say. Because you got to have faith, the faith, the faith. Baby. Anybody else love George Michael as much as I did? I was devastated when he died.
There's one for the state and one for the defense.
Look at him. He prints up orders from the bench. He rules from the bench. He prints it up. He passes it out. He knows technology. He doesn't go in the back for a 20-minute phone call to get advice on what to do. He's doing it. He's getting it done. Matt White for Supreme Court. And George Michael Cleo, guilty feet have got no rhythm yet. Yeah, Dan plays bass. The defense lawyer is terrific fighting for his client.
All right, state, call your next witness.
Zealous representation, my friend. You're watching a masterclass.
All right, who's your next witness?
Oh, Detective Chris Gillum.
All right, go ahead and bring the jury in.
Got a detective coming up to the stand, folks. A detective coming up. They're going to bring the jury in. Give him a minute.
Research on any of the things we talked about. Everybody says more. As you need, and just speak in a loud, clear voice, and it should pick up everything.
Yes, sir.
Notice how he doesn't threaten to shut off the air conditioning if he doesn't speak loudly enough. Wow, this is so different. Covering a different trial is so different.
Good afternoon.
Good afternoon.
Please state your name.
Chris Gillum, Gillum.
Where do you work?
Manatee County Sheriff's Office.
How long have you worked there?
22 years.
And did you work somewhere else before for several years? How many years?
Yes, City of Palmetto Police Department for 12 years.
Okay. And what position do you currently hold at Manatee?
I am currently a domestic violence investigator.
And how long have you been in that unit?
12 years.
I said in that unit, but if you could just describe, does Manatee County Sheriff's Office have a unit for domestic violence?
Yes, we do. We have 4 detectives.
Okay. And where and how is that unit housed?
We are housed at our building is the 3500 block of 9th Street West is the actual address. And within our building, it's my unit and the Crimes Against Children detectives as well.
Okay. Were you in that same position back in 2017 to 2020?
Yes, I was.
Okay. Back then, did your department house child protection services?
Yes, at that time we did.
Okay. And explain that. Were they with you in the same area, or how did that work?
No, they were on the other side of the building. We had our own area and they were on the completely opposite side of the building.
And were they actually employees of the sheriff's office?
Yes.
Did you do a lot of stuff with them together? A lot of investigations together?
The domestic violence unit, we did not. Every so often, that was mostly the Crimes Against Children detectives that worked with them.
And as a domestic violence detective, have you investigated violations of injunctions and that type of thing?
I certainly have.
Okay. Now, sometimes when someone is asking for an injunction, or when an injunction is violated, it can be charged criminally, correct?
Correct.
Okay. Or they can take other avenues
That's
to address the violation. But you're not involved in that other avenue if it's a different court, correct?
Yes, I'm not involved in that.
All right. Did you become familiar at some point with someone named Ashley Benefield?
I did.
And when was that?
December of 2017.
Okay. Generally, what were the circumstances without it getting into a lot of detail?
She reported that her husband violated an injunction that was in place out of South Carolina.
Okay. And that came to you?
Correct.
Right. And we've heard several mentionings of poisoning. Did this have to do with the same issue?
It was the same case, yes, but I had nothing to do with that investigation.
Okay. So the poisoning itself, you didn't have any contact with. It was just the violation of injunction.
Correct.
Okay. Did you speak to Ashley?
I did.
How many times would you say you spoke to Ashley?
Jules, no, only on StreamYard. I can send you a StreamYard link if you want to come in later after the case is over. Let me know. You could email me and let me know if you don't mind.
I think a fair number would be 30 to 40.
Okay. And generally speaking,
I got to rewind that because I forgot what the question was.
how many times would you say you spoke to Ashley?
Spoke to her 30 or 40
I
times.
think a fair number would be 30 to 40.
Okay. And generally speaking, was that because you were contacting her or she was contacting you?
No, she started contacting me on a regular basis beginning around February of 2018.
Okay. And what was she contacting you about?
She was wanting to know the status of the case and when Doug would be getting arrested for the violation of the injunction.
Okay. And when you do a violation of injunction, when you're investigating a violation of injunction, you can do several things, correct? You can, well, explain what you can do with it.
We can make a physical arrest in a case. There could be no charges filed in a case, or we can send the case to the state attorney's office.
Okay. So if you send the case to the state attorney's office, what does that mean?
We're just letting them make the ultimate decision if they think there's enough for charges to be filed in this case.
Okay. So it sounds like
I'm seeing a couple of jurisdictional issues here. First of all, the restraining order was from South Carolina. Does the Florida Manatee County Sheriff's Office not want to enforce a South Carolina restraining order? I have questions about that. Number two, she's calling him 30 to 40 times starting in February of 2018 because she knows that her baby is coming. She's going to give birth in March of 2018. That says fear to me. I don't know. I'm sure a lot of people in other chats are going to spin it in different ways. But right, prodigal mom says she was scared walking on eggshells, getting along to protect her daughter, in my opinion. All right, so
there's no charges and then arrest and
yeah, well, she's just reading the papers out loud that she can't get them in any other way. So she's going to read the papers into her question. She's starting to make me mad. All right, let's listen.
so if you send the case to the state attorney's office, what does that mean?
We're just letting them make the ultimate decision if they think there's enough for charges to be filed in this case.
Okay. So it sounds like there's no charges and then arrest and
Sustained.
so you said Ms. Benefield was calling you asking about the arrest of Mr. Benefield.
Yes.
Okay. And what did you tell her?
That the case was still suspended at that point, and when I had an answer for her, I would let her know.
Okay. And so that was the beginning of your conversations,
Yes.
right? So, did she continue to call
Yes, repeatedly, twice a week at least.
and speak to you personally?
Yes.
And what was her comments? What were her concerns?
It was the same thing. When was Doug going to be arrested for violating the injunction?
Had you ever told her that he was going to be arrested?
I did not.
But he
At
kept
some point, did you decide to forward the charges?
We heard one of
I
the
did.
detectives the other day testify, and he was presented with 2 police reports for 2 calls to Ashley's mom's house in Bradenton, where he was in the driveway of her house, and then another one where he was in the neighbor's yard looking into her house. And those, I believe, those were in 2018. Would have to go back and look at my notes. So she's wanting to know when he's going to be arrested, and this investigator is telling her not yet or not.
And is that to the state attorney's office like we talked about?
Yes, it is.
Okay. Did you inform her of that?
I sure did.
Okay. And what was her reaction to that?
She was upset that he was not being arrested.
Okay. Were you able to explain to her that the process and how this was going to go?
Sustained.
Were you able to explain the process to her?
Yes, I was.
Okay. And how did she take that?
She was not happy that I was not placing Doug under arrest.
Okay. At some point, did you speak to Ashley Benefield again? And she told you about a court hearing?
Yes.
Okay. Approximately when was that conversation?
Around the first week of May 2018.
May 2018. And what did she say?
She just got right into the phone call and requested that I arrest Doug for a hearing that was coming up in Manatee County.
Okay, you just said arrest for a hearing.
Yes.
But arrest At a hearing?
Yes, that there was a hearing, upcoming hearing in Manatee County.
And was that hearing involving your case or something else?
Or do you even
It
know?
was something else. It was not my case.
Okay. Did you know that there was a hearing or there was even a court issue going on?
I did not.
How could he not? He was
So
properly
she told you
investigating.
there
Wouldn't
was
he
a
know?
court hearing, and did she tell you when it was?
No, that just shows there was an upcoming hearing, and she asked for me to arrest Doug when he came inside the courtroom in front of the presiding judge.
Okay. And what was your reaction to that?
That absolutely would not occur.
Okay. And how did she take that?
She was upset. And at that point, I would call it a dramatic cry, hysterical cry started happening. And I'm still informing her, we're not going to do that. We're just not going to arrest him in the courtroom. And she made a comment, something to the effect of, if the judge sees you arrest him, this will help me keep my baby. So I thought that was a pretty bold statement. And I'm like, I'm still trying to give her the benefit of the doubt. She just gave birth. Maybe she's confused. And I'm trying to explain to her gently, that's just not going to happen.
You're still trying to give her the benefit of the doubt? As a domestic violence investigator, it sounded like you were giving her a mulligan. I decided I would, still give her the benefit of the doubt, even though she sounded hysterical, in his own words, hysterical crying. I'm still trying to give her the benefit of the doubt. I mean, tell me how you think that's going to fly. Let me just take that back a second. It would help her keep her baby.
And she made a comment, something to the effect of, if the judge sees you arrest him, this will help me keep my baby. So I thought that was a pretty bold statement.
Bold.
And I'm like, I'm still trying to give her the benefit of the doubt. She just gave birth. Maybe she's confused. And I'm trying to explain to her gently, that's just not going to happen, especially not going to happen for a judge to see to help you in a civil matter.
So
And-
when women just give birth, they're hysterical? So you thought you'd give her the benefit of the doubt because of her hysteria from having just given birth, because having just given birth would make her confused? Is that what I just heard that guy say? Still trying to give her the benefit of the doubt because, she just had a baby and she might have been confused. Now we are confused after having a baby. Okay. It wouldn't about helping her in a civil. He's investigating alleged domestic violence. He said that's what he does there, right? There are now proceedings going on in Florida, and he's not aware of them. There's a disconnect here, and I'm not sure what it is, but we're going to wait for cross-examination.
Did you in fact explain all that to her?
Yes, I did.
And how did she react?
We went back and forth 5 minutes or so. Her just kept requesting to arrest him. I said, this is not going to happen. And her tone turned from the crying to very aggressive. And she says, you will effing arrest him in front of the judge and I will make sure you do it.
Oh, she was very aggressive with you.
What did you say to that?
I started pushing back a little bit and I said, it's not going to happen. Whatever you say or do, you cannot make me arrest somebody in front of a judge, and it's just not going to happen.
And what did she do?
I guess she started crying again and came out with a comment, something like, I can't believe you're willing to allow Doug to kill me and the baby.
Okay.
And that's an odd comment. I can't believe you're going to allow Doug to kill me and the baby. Do they think that this is helping them? The prosecution? Because this witness is telling you that she was afraid that he was going to kill her and the baby going all the way back to May of 2018. So that proves her fear of being killed and fear that he would harm her child going all the way back to May of 2018. Thank you, Jen. This is why women don't report things, because we feel that no one believes us, says Jen K. Unbelievable. Dahlia Lynn says this is just making her look better. She was scared to death. Really, sir? Listen to that again. Really? You're willing to allow Doug to kill me and the baby? Okay, go with that.
I guess she started crying again, and she came out with a comment, something like, I can't believe you're willing to allow Doug to kill me and the baby.
Okay.
And that hadn't come up in this phone call. That the phone call dealt with me arresting Doug in front of a judge. And then it turned to arresting, or not arresting him, and allowing me to let him kill her and the baby.
Okay.
Because she
So that
had
seems
an
kind of-
order of protection against him. Is he really that dumb? She had an order of protection against him in South Carolina that he was violating. He was stalking her in Florida. She's asking you to arrest him for the violation of the protective order, the restraining order in South Carolina. And you think the two things have nothing to do with each other? Am I in the can I have some Twilight Zone emojis in the chat, members, please? Am I in the Twilight Zone? He can't make the connection. He's like, it has nothing to do with it. She's asking me to arrest him in court. No, she's asking you to enforce the South Carolina protective order. Twilight Zone emojis? Anyone? Where are we here? Where are we? This is someone who's supposed to be investigating DV complaints. This is his job for 22 years. And this is his attitude about this. He couldn't even understand the connection. Okay, deep breath. Wow. I don't think this is good for the prosecution. Do you?
Kind of different to you
Yes.
than what you had previously been.
Yes.
Okay. How long did this conversation go on?
20 to 30 minutes
Okay.
for up to that time. It's probably 20 to 30 minutes.
Okay. And during this time, excuse me, did the defendant ever seem to understand the process of what you were saying?
No.
And at some point, did she change from crying again?
She did.
What did she do?
It just abruptly changed, and she let out like a screech or a high-pitched scream. And she says, I'll do whatever I have to do to kill my baby or keep my baby, you a-hole.
Okay. So it's a high-pitched scream, or did you say scream or screech?
Like a screech at first, but it was I'll call it a screech.
A screech.
Yeah.
Screech.
And tell me, what volume is this?
I could just say it's a very loud, maybe top of lung type scream.
Okay. Could you demonstrate to us?
It's impossible. There's no way I could.
No way that you could
Why would
possibly
it be impossible?
screech like a hysterical woman who just had a baby that you were still trying to give the benefit of the doubt to. And if I was the defense, I would object to this anyway. We don't need to hear him screech. Notice the choice of words: screech, hysterical, willing to give her the benefit of the doubt. She became aggressive, crying, hysterical, high-pitched screech. Trying to paint a picture that she's crazy? Wow. Okay. It would be totally impossible. There's no way I could ever imitate that screech.
I couldn't get my voice that high. There's
Okay.
no way.
So it was loud and it was high.
Yes.
And she said, can you repeat what she said?
I will do anything I have to do to keep my baby, you a-hole.
You a-hole. And did she say a-hole?
No, she said the full word.
Okay. And after she said that, what'd she do?
At that point, I had checked out of the phone call, and I was pretty much ready to hang up the phone on her. And she accused me of conspiring with Doug to get her baby taken away.
At that point, I had checked out of the phone call and I was just going to hang up on her. Because that's what they do in the DV department. The Manatee County Sheriff's Office, they just check out and hang up on victims or alleged victims who are being stalked by their estranged spouse, who they currently have a valid order of protection against. And if you listen to the prosecutor's tone, oh, good, I can take this down because now they have it on the screen. If you listen to the prosecutor's tone, it's like she feels like she's scoring points here. And I think that some very wise women on the jury, there are 7 women who could potentially sit on the jury of 6 that are older in their 60s, 70s, and 80s. I think wise women are going to be mad about this testimony. I don't know. You tell me what you think. She's accusing him of conspiring with Doug to get her baby taken away. So what? She must be paranoid.
And had you even spoken to Doug about custody of the child?
No.
Were there other detectives around you at the time of this phone call?
Yes, there were 2 other detectives.
And do you recall their names?
Oh, yes. Detective Patricia Hetrick and Detective Brian Morland.
And did they appear to recognize that you were on a difficult call?
Oh, they did. And at one point, Brian even asked me if I needed some help.
It's the same.
And at some point, how did the phone call end?
Ms. Benefield terminated the phone call.
Oh, you didn't hang up on
you
her?
seem to have a good memory of this call.
Yes,
And why do you have a good memory of this call?
because in my 12 years of doing this, I've never had anybody ask me to arrest someone in front of a judge inside of a courtroom. Now, I have had people call me before and say somebody may be appearing in court that I'm looking for so I can arrest them, but I've never had somebody say, wait until he's inside the courtroom in front of the judge.
And that's why this stuck out to you? Again, Janai says this is why we don't tell. He was stalking her. She knew that he was going to be there that day. And therefore said this would be your opportunity to arrest him, because was he even living in Florida at that point? I don't know. But she's telling him that he's going to be there that day, and therefore it would be a place that you could arrest him for violating the order if you can't find him. But he's more concerned with the fact that she said do it in front of the judge. Is that what I'm getting here?
Thank you. No further questions.
Cross?
Oh, yeah. Let's go.
Just a moment, Your Honor.
Thank you, Barbara DeLong, for your super sticker. Black Rose, member for 4 months and an amazing moderator for this channel. Thank you. Loves the attorney. Melissa loves seeing the notorious jewels in the gallery. Real Crime Jess and Rosie, thanks for becoming a new member. Welcome.
Afternoon, Detective Gillum.
Good afternoon, sir.
I want to ask you a few questions about report writing.
Sure.
Do they teach that to you in police academy?
Sure. Back in 1989, they did, yes.
Okay. It's obviously an important part of police work.
Sure.
How many cases would you say could you average that you handle in a month?
20.
Okay. And over the course of a year, we're talking about
300 close.
So are you familiar with the saying that they give you in police academy, if it's not in the report, it didn't happen?
I've heard that before, yes.
All right. And that's because the report is obviously more reliable than your memory.
I could understand that, yes.
All right. At 20 cases a month, 2.5 years later, you're into like 600 cases. If you got your report, you can refresh your recollection rather than have to recall off the top of your head.
Sure.
Which is why you want to put critical details in your report, because that's what you want to remember.
Correct.
Not necessarily that somebody had on mismatching socks, but that they had something that's significant to the investigation.
Sure.
All right. So your initial involvement, you told us in the case, is speaking with Ashley Benefield on or about May 31st of 2018 regarding the domestic violence injunction in South Carolina.
That wasn't the first time I spoke with her, no. There were several incidents I spoke several times I did.
Did you speak with her on or about the 31st of
I was
May?
prior to that.
Okay, about the South Carolina injunction.
Yes.
All right. And just to be clear, we're talking about the same thing. There was a court that had issued an injunction in South Carolina, stay away from one another.
Yes, in South Carolina, that is correct, sir.
Okay. Now, at some point, did you bring any of the reports that you wrote with you here today?
I did.
Do you recall how many you wrote?
Supplemental reports, 3 or 4.
Yes. All right. So initially, if I can ask you about the sequence of these events, Ms. Benefield had gone down to the Manatee County Sheriff's Office to complain about a package that she received because it came while the South Carolina injunction was in effect.
Yes.
All right. And it would have been Deputy Wesley Weber, to your knowledge, had requested a capias based upon Ms. Benefield's receipt of that package.
Correct.
Just so the ladies and gentlemen of the jury understand, a capias is an
Objection.
arrest warrant.
It's testifying, and
Sustained.
it's all hearsay.
What is
Just
a
use the word
capias?
arrest warrant.
A capias is information where a deputy believes that there's probable cause for someone's arrest.
All right. That was issued by Deputy Wesley Weber.
Correct.
And that would have been on December 14th of 2017.
That sounds correct.
Now, a month later, well, actually, several months later, on May 31st of 2018,
Objection, Judge. I called for hearsay, but I apologize, I wasn't finished the question.
did you write the first of your supplemental reports?
Yes.
And in that report, you stated that Ms. Benefield,
Objection. Hearsay.
Sustained.
in the report, did you indicate,
Objection, hearsay.
Sustained.
Why is the report hearsay if it's his report?
did you write anything in your report in describing,
Objection, hearsay.
Can you approach, please?
hold on,
Ask him the question, and then if he doesn't remember, you can refresh his recollection with the report. He knows how to do this. He's just on a roll
let
right
me
now.
have one more shot at it.
Go. We'll give you another shot.
Did you document in your report anything different than you told us here today about how you characterized Ms. Benefield's demeanor?
I didn't go into any details in that supplement at all, in that one.
Oh, so now you're adding details. Wow, this is Karen Reed vibes a little bit, right? Adding details on the stand that were not in your initial report. Okay.
May I show him the report?
That's why the objection, Mel, because he has to get it in first and then use the report to refresh his recollection. Use it to impeach him or use it to refute because the report's not evidence.
Judge Kelly?
Yes.
Trevor wants to know why he's so arrogantly sitting sideways. I think he's facing the jury. I think he testifies a lot, probably, and he probably feels that it's in his best interest to face the jury.
During that time, Detective Gilliam, back in May of 2018, you overrode Deputy Wesley Weber's capious request, correct?
I did.
Okay. And you put the case on an inactive status.
Yes.
And I think
So
you
another
decided-
detective decided that there was probable cause to arrest him, and he overrode that report. I want to see what detective he's talking about, so we'll know when that detective comes up.
During that time, Detective Gilliam, back in May of 2018, you overrode Deputy Wesley Weber's capious request, correct?
I did.
Okay. And you put the case on an inactive status.
Yes.
And I think you decided, as you told us, it would be submitted to the state attorney's office.
That is correct.
What did the state attorney's
Now,
office do?
on
Nothing.
June 5th of 2018, you interviewed Douglas Benefield, did you not?
Correct.
And he admitted to you.
Objection, hearsay.
What did he say to you?
Sustained.
What did he
What
say to you?
was his position with respect when you asked him,
Objection, hearsay.
Finish the question.
did you send the package to Miss Benefield?
Sustained.
Did you make a determination from your conversation with Mr. Benefield whether or not a package had been sent to Miss Benefield?
Objection, relevant.
Overruled.
Relevance?
Can you ask the question again, please?
It's violating the order.
Did
There's
you
no
make a
relevance.
determination as a result of your investigation whether a package had been sent to Miss Benefield?
Yes.
Did you make a determination as to who sent it?
Yes.
Who?
Douglas Benefield.
He sent her the package.
Did you make a determination of what the contents of the package were?
It was a tea set.
And was hazmat called?
Objection, Judge. Hearsay.
Sustained.
As part,
Did you say hazmat?
yes, sir. As part of
Sustained.
As part of your investigation, did you make any determination whether or not there was a response by
Objection, hearsay.
Any other?
any other agency to this package that was sent to Miss Benefield?
Objection, hearsay.
I didn't hear the ruling. Sustained?
Sustained.
That was early. Okay, for those of you who don't know, Ashley Benefield made allegations that she thought her estranged husband, by this point, was trying to poison her by feeding her specific tea. He would bring her tea in the morning, he would bring her tea at night. She would complain to him or tell him that it tasted abnormally sweet. And that's why she went to the hospital in March of 2018 before her baby was born, because she was under the impression or thought that he was poisoning her. And she had some results done at some lab that's indicated that she had very high levels of heavy metals. I don't know if all this is going to come into evidence. And that is why she was induced. That's why the baby was born a couple weeks early. And now we see in June of 2018, which is after the baby's born in March, there's a protective order in place. He sends her a tea set. And apparently the hazmat crew showed up because she's terrified. She thought he was poisoning her with the tea, and now he sends her a tea set. So those of you in the chat can opine what you think the tea set meant. Was it a warning? Was it I don't know. You tell me what you think. See if it comes in.
Did you tell Mr. Benefield that you would be able to unfound the case if he sent you the receipt? I'm asking him if he told Mr. Benefield.
Can you please approach?
Did you tell Mr. Benefield?
Can you please approach? Can you please approach
Oh,
the bench?
sorry.
I love this chat. You guys get it. Sending her a message, threatening. That's effed up. Prosecutor does not want this in.
I think the last question I asked you was, did you tell Douglas Benefield you could unfound the case if he sent you the receipt for the sending of this package of tea?
No.
So did you write a supplemental report as a result of this interview with Mr. Benefield?
Yes.
And this would have been on June 5th of 2018.
That's correct.
Now, did you put and document in that report anything about Miss Benefield?
I would have to look. If you don't mind, I can certainly.
Please.
I challenge you later to go to other chats and to find this part of the testimony and to watch the chats and tell me what you see.
That was on when? Determined package.
Wait, hold on.
No, I don't see anything about Ms. Benefield in the supplement.
Okay, you did determine though that the package, once you got the receipt, you determined the date the package was sent.
Yes.
And that was on when?
November 27th, which is when the injunction was signed off on by the judge. It was the
Yeah.
same day.
But you also determined that the hearing on the injunction was November 3rd, 2007.
That was the hearing, but the judge did not sign off on this until the 27th, which was the same day. So,
Right. But at the hearing, Mr. Benefield was present when the judge announced.
yes, when he announced, but it was
Okay.
my understanding it's not in effect until the judge granted his signature on the 27th, which is the same day that Mr. Benefield sent out that T-set.
Okay, who is the lead detective in this case,
For which case?
for the homicide case?
I'm not sure.
Is it Detective Warren?
I don't know.
Do you recall contacting Detective Warren on November 30th, 2020 at 7:47 a.m.?
I do remember contacting him. I'm not sure if that's the date, but yes, I did.
Okay. And do you now recall that Detective Warren is the lead homicide investigator?
I'm not sure if he was the lead. I know that he was at that scene, but I'm not sure if he's the lead investigator.
Okay, so you talked to Detective Warren on that day.
Yes,
All right. You then, 16 days later, Detective wrote another supplementary report, correct?
I'm not sure if it was 16 days later. I would have to.
Why don't you take a look and see if that report isn't 16 days following your contact with Detective Warren.
And when did you say I contacted Detective Warren?
You contacted Detective Warren on September 30th, 2020 at 7:47 a.m.
Yes, I entered a supplement on October 15th of 2020.
Okay. Now, following your conversation with Detective Warren on that day, September 30th, 2020 at 7:47 a.m. in the morning, you write a third supplement, do you not?
Correct.
And it's dated October 15th, 2020.
That is correct.
16 days after speaking with Detective Warren.
That is correct.
In that supplement, you list, do you not, the details of what you described today about how Miss Benefield behaved.
That's correct.
So let's make sure we understand this now. This is 2.5 years following the discussion that you related to the ladies and gentlemen of the jury of Miss Benefield's response. 2.5 years later, you remember the details of the conversation
Absolutely.
and exactly what she said. Quotes, you quote her.
Yes.
Mm-hmm.
But you never mention one word of it in your supplement that you wrote on June 5th of 2018.
You are absolutely correct.
Wow. Wasn't in the report. Didn't happen,
Nothing
right?
further. Let me just check.
He absolutely remembers that conversation because no victim of DV has ever stood up to him before and called him an a-hole. Wow. It's not in the report, but he remembers it today. What say you, my friends? What kind of credibility does he have to the jury?
Okay, that's all. Thank you. You direct?
Why didn't you add that information to your supplement back in 2018?
In my initial supplement, which was May 31st, I did put in that supplement that she demanded an arrest be made in the courtroom when he appeared. At the time of my interaction with her, I didn't see anything she said at that time as a direct threat to Doug. It had no relevance to my case. I saw this as her just having this massive meltdown because she wasn't getting her way with me. So
Wait,
at that point,
you didn't see her as a threat to Doug? What? Okay. Hold on. Wait, Scott, did you get Scott's wrencher was broken. I got to fix Scott. Give me a second. Scott, are you back to being Scott? Okay, here we go. I got to put Scott back. One minute. This is important. Scott. Scott. Can I not do it from my phone? I got to hear what he said again. I did not think that she was a threat to Doug. Okay.
The details of the conversation. Think further. Let
Initial supplement,
That information to your
Thank you.
Redirect?
Why questions are usually questions that lawyers don't ask. Why did you do this? Why did you do that? Because you never know what the answer is going to be. But she must have prepped them, so she has an idea. Listen.
Why didn't you add that information to your supplement back in 2018?
in my initial supplement, which was May 31st, I did put in that supplement that she demanded an arrest be made in the courtroom when he appeared. At the time of my interaction with her, I didn't see anything she said at that time as a direct threat to Doug. It had no relevance to my case.
As a direct
I saw
threat to
this as
Doug.
her just having this massive meltdown because she wasn't getting her way with me. So
Doug was a threat to her, not her being
at that
a threat
point, it
to
was just
Doug,
not relevant.
sir. It just wasn't relevant because she wasn't a threat to Doug. She was just having a massive meltdown with you. I have no words.
For my case. There was no reason, but circumstances have changed. I thought that's information that needed to be heard.
Okay. So, and what circumstances?
Obviously, Mr. Benefield is deceased at this time.
Okay.
And her words at that time may have had an entirely different meaning. I did not take it as a threat. I took her saying that I'll do whatever I have to do to keep my baby, you a-hole, as my manipulation attempt for the court system. Not that she was going to create any harm to Mr. Benefield. Now, she never mentioned anything like that. She was never any threats. But I just took that as a manipulation attempt. When she wasn't getting her way with me, it was a meltdown. And there was just no reason for me to put that in my supplement that she was having this massive meltdown because
3 times.
I wasn't going to buy into it.
3 times he said meltdown. 3
And
times.
so
But
after
he wasn't going to buy into it
she
because
murders
he
Doug
does not believe victims. He said meltdown 3 times. What does every linguistic expert on YouTube tell us? That 3 times is the sign of deception. That every time somebody or a witness repeats something 3 times, they're being deceptive. OMG. I didn't see her as being a threat to Doug. Did you ever see Doug as a potential threat to her? Wow. We have to hear that again for emphasis because I am just wow. And the fact that the prosecutor thinks that this is helping her in any way, shape, or form is mind-numbing to me. Listen to how many times he says meltdown, because I think you already said it once before. I didn't see anything she said at that time as a direct threat to Doug. No, but she did say, "You're just going to allow him to kill me and my baby?" And she's just having a meltdown. You didn't believe a thing she had to say? And that there was an actual restraining order against him from the state of South Carolina that didn't factor into the meltdown and the fact that he sent her a T-set and he's not supposed to have any contact with her. There's a no contact order. Look at her face. I see you in the chat. I see you in the comments. I know what you've been through, my chatters. This is so triggering. If you need to take a break, go take a break. I have no words either, and I'm rarely at a loss for words, but let's listen to this a-hole. You know what? She was right when she called him an a-hole, my friends. She was right.
I didn't see anything she said at that time as a direct threat to Doug. It had no relevance to my case. I saw this as her just having this massive meltdown because she wasn't getting her way with me. So at that point, it was just not relevant for my case. There was no reason, but circumstances have changed. I thought that's information that needed to be heard.
Okay. So, and what circumstances?
Obviously, Mr. Benefield is deceased at this time. Okay. And her words at that time may have had an entirely different meaning. I did not take it as a threat. I took her saying that I'll do whatever I have to do to keep my baby, you a-hole, as my manipulation attempt for the court system, not that she was going to create any harm to Mr. Benefield. Now, she never mentioned anything like that. She was never any threats, but I just took that as a manipulation attempt. When she wasn't getting her way with me, it was a meltdown, and there was just no reason for me to put that in my supplement that she was having this massive meltdown, because I wasn't going to buy into it.
And so after,
I wasn't going to buy into it. He said meltdown at least 5 times. He said manipulation at least 3 or 4 or 5 times. This is crazy.
she murders Doug Benefield, you thought it was relevant,
I
obviously.
thought that was very relevant information that needed to be heard.
And did you reach out to someone about that?
I did.
Or did they reach out to you?
I reached out to him.
You reached out to Detective Warren,
Yes.
correct? Okay. Thank you. No further questions.
Did Detective Warren direct you to write this up?
Absolutely not. I wouldn't take orders from him to begin with.
Oh, you don't take an order from anybody.
2.5 years later, you remember that she said specific things. This will help me keep my baby if the judge sees you arrest him, quote unquote.
Yes, because it's a very, very bizarre comment I've never heard before in my career.
That's like 600 something cases later.
That's fair.
That's all.
Okay, can you be released from the subpoena?
Yes.
Sir, you're released from the subpoena, you're free to go.
Thank you, sir.
Wow.
No, I'm sorry, Judge. You are. Sorry.
Detective Gillum.
Good. Keep him under your
Sir,
subpoena.
you have not been released from your subpoena. The rule of sequestration has been invoked by the attorney.
I
That means that you cannot discuss with any.
have no words for what we just heard in this courtroom. Where's
One,
shock and
your
horror?
test-
Where's our viewer shock and horror? Sarah, I think it's Sarah shock and horror. Like what? Manipulation. Meltdown. I didn't feel like she was a threat to Doug. But then after she killed him, I went back and amended the report. Not once did he ever think that she had justifiable fear. Not once did he ever think that that order of protection in South Carolina was valid. I'm horrified. Yeah, we'll play back what he said about not taking orders from the other detective. This is horrifying me. Where's Olivia Benson when you need her? Somebody who's got empathy for victims. Was that the
Create any harm to Mr. Benefield. Now, she never mentioned anything like that. She was never any threats, but I just took that as a manipulation attempt. When she wasn't getting her way with me, it was a meltdown, and there was just no reason for me to put that in my supplement that she was having this massive meltdown, because I wasn't going to buy into it.
And so after
I think it was during questioning of Taylor, right? When he said that about he doesn't take any. Here we go.
Needed to be heard.
And did you reach out to someone about that?
I did.
Or did they reach out to you?
I reached out to him.
You reached out to Detective Warren,
Yes.
correct? Okay. Thank you. No further questions.
Did Detective Warren direct you to write this up?
Absolutely not. I wouldn't take orders from him to begin with.
And 2.5 years later, you remember that she said specific things.
I wouldn't take orders from him to begin with, is what he said about Detective Warren.
This will help me keep.
Wow. Sinbad 333 says, okay, I've decided Ashley's not guilty. She had no other way out. No one was helping her. I'm gonna let's just take a break for a minute and look at some questions, because we need a break after that disgusting, repulsive testimony, in my opinion. I'm rarely speechless. Sometimes you'll see it, but rarely. Michelle says, so far, all her actions have stayed consistent with being scared of him, trying to get legal help, in my opinion. Michelle, I think that your opinions were just justified, validated by the witness that we just saw on the stand, who is a DV investigator for the Manatee County Sheriff's Office. Ladies, if anybody lives in Manatee County, you may want to move. Thank you for the super chat. Michelle, thank you. I'm sorry, Melissa, thank you for the 10. Years ago, my abuser broke into my house in the middle of the night to arm me. I punched him and he left. An hour later, he called the cops, had me arrested, and I was convicted. Illegal to fight back? Oh my God, Melissa, I am so sorry that that happened to you. Sarah D, thanks for becoming a new member. You join a lot of Sarahs that are members here. Melanie, thank you so much for the 20. Don't know if good or bad. To me, it sounds like he doesn't believe her. Talking about this last witness that we just saw. I can't imagine how that testimony could play well in front of a jury. Melanie, thank you so much for the 20. And for your comments and for always being a participant in the chat. On top, thank you again for your super stickers as always. Thank you, Ash Axiom, for gifting a membership. You're so kind and generous. And Connie, thank you for the $10 super sticker. I appreciate you so much. New Hampshire woman's been a member for 9 months. One of the OGs. He reminds me of Dr. Evil, she says. After that testimony, I think we can nickname him that, Dr. Evil. Michelle says he's the reason we're here today. Thank you, Michelle. Christina Cooper, thanks for becoming a new member. Marilyn Glazier, thank you for the 5. I think he meant Doug wasn't a direct threat by sending a T-set, but he's still a dirtbag. I don't think that he thought Doug was a dirtbag at all. Thanks, Marilyn, for sharing your thoughts. Reality check, thanks for the 5. I'm a DV survivor. Please look into supporting Micah's law. We need it passed. Google Justice for Micah for more information. Thank you to all my armchair detectives in the chat who will, I'm sure, absolutely do that. Dickless Tracy, thank you for the deuce. He could transfer to MSP and fit right in. One word, Nikki McCain. Thank you, RN Homestead. It was you who brought that case to my attention of Nikki McCain. Thanks for the 10. Nikki McCain is a mother of 4 who is still missing in Northern California. Her family knew that she was being abused for at least 5 years. Her husband was facing 4 felony charges of DV up there in Northern California right now. The county escapes me. Shasta County, I want to say? Shasta County? She went missing. Her husband was cited for setting a wildfire or for causing a wildfire to be set that burned 100 acres. A lot of the neighbors had to be rehomed or evacuated. She's still missing. And because she's missing, the 4 felony charges of domestic violence have been dismissed against her husband. Dismissed because Nikki McCain no-showed to the court appearance. But never fear, said the prosecutor, because if she resurfaces within a year, we can refile charges. We're going to dismiss them without prejudice. So yeah, RN Homestead, thank you so much for that. And if you haven't watched my stream on Nikki McCain, please go watch it. It was not something that got a ton of views, and I'm disappointed about that because I think it's a story that needs to be out there. It's heartbreaking. And that's what happens. We don't know where she is. We don't know if she's going to surface, but we can speculate. Thanks, Karaoke, for gifting a membership. I appreciate you so much. Oh, you mean Dr. Evil is the dirtbag? Yeah. Oh, thank you, not Doug. Thanks, Marilyn, for clarifying. I'm like, what? He thought Doug was a dirtbag. I don't think he thought anything bad about it. This is just, I didn't realize that this trial was going to have so much craziness. I thought that they were going to come in and they were going to present this case and it was going to be locked down tight. And then we were going to hear all this evidence that Ashley was, actually had some motive and people are saying that in other chats, you're so surprised that people are saying she's guilty. Again, I think we're in the twilight zone, friends. I really do. I don't know what's going on out there. I don't know what happened to innocent until proven guilty. I don't know what happened to people not believing victims. I don't know what. This is 2024, you guys. And this is fucking horror. There's what looks like another law enforcement officer on the stand. So let's go back to court and see what they have in store for us next. Everyone breathe. We know. We see you. We know who's in this chat. And I feel like this is the only chat on the internet that is getting what's going on here. Let me know if you found another one. Let me know. I mean, I'm beyond.
Yes, ma'am.
Hello, sir.
Hey, how are
As
you,
the
sir?
deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches away from the microphone. It does adjust up, down, left, right. And if you just speak in a loud, clear voice right at the microphone, it'll pick everything up.
Thank you, Your Honor.
Good afternoon.
Good afternoon.
Please state your name.
Detective Brian Morland,
How do you spell both names?
BRIAN MORELAND.
And we've had some testimony about a Judge Morland. I just want to make it clear, is there any relation between you and Judge Morland?
No, ma'am.
I was going to ask that, actually.
What is your employer?
Manatee County Sheriff's Office.
How long have you been there?
Since 2004,
What is your current position with them?
I'm a crimes against children detective.
How long have you done that job?
Since January 2011.
And crimes against children, is it known by an acronym?
CAC.
CAC. Okay. So if you hear CAC,
We wanted to know what CAC was, and that's what it is, Crimes Against Children. If he's as savvy as the DV investigator, I think we're in for a treat. Let's see. I'm not going to prejudge him. Breathe, breathe. Everyone just breathe. Did you say crimes against children? Hold on.
is your current position with them?
I'm a crimes against children
Crimes
detective.
against children.
How long have you done that job?
Since January 2011.
And crimes against children, is it known by an acronym?
CAC.
CAC. Okay. So if you hear CAC detective, that's what we're talking about.
That's correct.
All right. So you've worked in that capacity for several years. So you were working in that capacity between 2017, 2019?
Yes, ma'am.
Okay. What does the CAC unit investigate?
Any crime that involves a child, any crime against a child, I should say. Sexual abuse, physical abuse, malnourishment cases, things of that nature.
And we heard that your office, you share an office space with other departments?
Yes.
And what are those
The
departments?
domestic violence unit is also in our office.
Okay. And back then, 2017 through 19, there was another entity in there with you? The child protection services, were they in your?
Oh, I'm sorry. Yes, DCF was in there.
DCF. Okay. I apologize. The letters have changed over the years. So,
Obviously, yes.
all right. Did you do a lot of investigations alongside specifically DCF or child protection services, what I call it?
So being in a crimes against children unit, we often work very closely with other agencies, DCF especially. My job as a law enforcement agent is to investigate crimes, basically. The child protection investigators, their job is to protect the children and offer services when needed.
Okay. So they have different goals.
Correct.
All right. When there's an allegation of child abuse, just generally, what is the protocol? To who investigates, who gets the information? Like, how does that go?
Generally, a report will come through the abuse hotline. Law enforcement gets notified, and DCF or child protection investigator will get notified, assign the case, and go out. We usually do that in tandem. So
we're all there at the same time. And like we said before, different goals.
Different
When we
goals, but
get
you're
there.
there at the same time,
That's correct.
typically? Okay. And sometimes reports can come in, someone can just walk into the station, correct?
Oh, yeah.
Or call or do something like
Yes.
that with the sheriff's
And
office.
if we get it first, then that deputy, whoever's writing that report, contact the abuse hotline.
Okay. So I want to talk about, well, first let me ask you about Detective Gillum. So you said you're with the domestic violence unit.
That's right.
Do you know Detective Gillum?
I do.
Have you worked side by side or at least in the
We've
same
worked in the
space?
same office for many years, yes.
Okay. And he just testified about a phone call that he had that he remembers quite well.
Yes.
Do you recall him having a interesting phone call?
I remember the phone call. Yes.
Okay. Were you sitting there?
We shared a cubicle wall, so we couldn't actually physically see each other, but we could hear, obviously, everything that was going on.
Okay. And did this seem like a typical phone call that he?
He seemed quite exasperated at the end of that phone call.
Okay. At the time, did you know who Ashley Benefield was?
Yes.
Did you later become involved with Ashley Benefield with reference to CAC?
Yes.
Okay. And around December 2019, were there several investigations that came in, started a series of several investigations that came into your department?
Yes.
Okay. So I want to ask you about the first report or the first investigation. About when was that?
Can I refer to my report?
Sure, go right ahead.
December 10th, 2019.
Okay. And generally speaking, what was the complaint?
Judge, based on prior motions and we.
Yes, sir. I understand. Oh, go ahead.
Thanks, sir. This investigation involved allegations of sexual abuse.
Okay. So sexual abuse, obviously of a child.
Yes, ma'am.
And who was the child?
I'm going to turn off the closed captions for this part of it because YouTube has a weird thing with AI and they go through your video. And if it says something like that, they demonetize it, which is fine, except for then it gets shadow banned and nobody can find this safe place for, as Miss B says, she's new here. She says, hi, I'm a DV survivor and I'm reeling here. Ashley is so strong and she is not guilty. We're so glad you found us, Miss B, because this is a safe place for you. Everyone say hi to Miss B. Here's the thing about some of these other chats that you guys are bringing up is that I don't know if it's more about like sub counts for certain people, and I'm not naming anyone in particular. I would rather have 65,000 kind people subscribing to my channel than have 300,000 mean people subscribe to my channel. So it's a carefully cultivated community. And if people don't like what I have to say or the way that I stand up for victims, because that's what I did for the entirety of my 30-year legal career, including handling the majority of the cases in New York against the Rockville Center Diocese for victims and survivors of clergy SA when that whole scandal broke back in 2002. So this is my wheelhouse. This is what I do. People that want to be mean and vitriolic can go somewhere else. Like they don't need to subscribe to my channel. I don't care. It's not about the numbers for me. It's about kindness. It's about showing grace for people and what they've been through. And so I don't know if that's why that goes on in other chats, but my moderators are fiercely protective. Retired law enforcement, people who have been through it, women who get it. And we're mad as hell and we're not going to take it anymore. And I'm not going to tolerate it. And thank you, BJM. Safest place I have ever. I'm just not doing it. I'd rather have people not subscribe to me if they don't like what I have to say. But we need to show some kindness. My God, man, what is going on out there? It breaks my heart. Does everyone on the internet have to be mean troll? I feel like we're outnumbered by mean. I really do. Well, that's my speech for the day,
Emerson Canny.
for now.
And who was the complaint against?
Douglas Benefield.
Objection. Oh, I'm sorry, withdrawn.
Is it the same objection?
No, withdrawn.
Go ahead, ma'am.
So did you get assigned to the case?
Yes, ma'am.
Right. And so just as a matter of procedure, when you initially, when Manatee County Sheriff's Office gets a case, you're not initially assigned right away, right?
No.
What happens before you get it?
Generally, what happens in cases like this is however we receive the report, whether it be through the hotline, whether it gets reported directly to the sheriff's office, a uniformed deputy along with a child protection investigator will go out to the scene. The uniformed officer will normally write the information down in a report, and that information gets filtered through our supervision. And if it needs to be assigned, it's assigned.
Okay. So theoretically, on this particular complaint, there had been some work done before you got it.
That's correct.
Okay. And then did you continue that investigation?
Yes, ma'am.
And as part of that investigation, was Emerson sent to the child protection team?
Yes, ma'am.
And what is the child protection team?
The child protection team is a state-funded team that for
Same objection, Your Honor.
Sustained.
for my criminal investigation.
Sustained.
sorry.
Means don't talk.
Next question.
Stop talking.
Did you talk to Douglas Benefield?
Yes, ma'am.
Okay. Did you also speak to Ashley Benefield?
I don't recall if I spoke with Ashley on that particular case. I believe she was interviewed already.
Okay. And what did you do with the case? Were any charges filed?
No, ma'am.
Okay. So I want to talk to you about the second report, and that was what date?
Report date was March 21st, 2020.
Okay.
March 21st.
2020.
Generally speaking, what was that allegation?
That was a physical abuse allegation.
Okay. Physical abuse against,
Douglas Benefield.
and the victim of that would have been?
Emerson.
Okay, same parties.
Mm-hmm.
Do you hear how the prosecutor keeps going, okay, as if she totally doesn't believe any of it? Okay. We're going to stay here in our bubble, Missy Rodriguez. Our bubble is good. We like our bubble. Aries girl, why do us women have to be unalived or missing to be believed? Right? And then everyone says, oh, we should have done more. We should have done something.
And how old was Emerson at the time, approximately?
2 years old.
And again, the same question, had some things been done before you got the case?
Yes, ma'am.
All right. Did you continue that
I
investigation?
did.
And at some point, did a second complaint come in before you were finished?
On the 23rd of, so March 23rd, 2020. Yes.
Okay, so a couple days later.
2 days
And
later.
what was this complaint?
It was again physical abuse.
Different than what came in a few days before?
Yes.
Okay. Did you investigate those two things together?
I put them in the same report. Yes.
Okay. And what did you do with those cases?
No charges were filed.
And I'd like to talk to you about the third report. When did that come to MSO, or when did you get it?
April 5th, 2020.
Okay. And generally speaking, what was that allegation?
Physical abuse.
Of Emerson?
Yeah.
And by Doug
Douglas.
Benefield?
Yes.
And once again, before it was over, did you get another complaint?
On the 27th, another deputy responded.
Okay. And what was that complaint?
Again, physical abuse.
Same parties?
Yes.
Did you again investigate those two case numbers together?
Yes.
And what did you do with those cases?
No charges were filed.
No charges were filed.
At some point, were you a part of what's called a staffing?
Yes.
And what is a staffing?
A staffing is when the entities, as I mentioned before, come together and try to find a good way, or moving forward, a good way to protect the child.
Okay. And did you attend a staffing on this particular case?
The Pletford
The
case.
Benefield,
Yes.
yes. And as a result of that, were Ashley and Doug assigned to go to therapy with Dr. BROEDER, or not therapy, an evaluation with Dr. BROEDER?
Yes, ma'am.
Okay. Thank you. No further questions.
Cross?
Yes.
I
Yes.
can't.
Cases that if you just a few questions for you,
Yes, sir.
Detective Moore. The cases that you referred to, I think you said there were 5 of them.
Yes, sir.
I don't want any details.
Okay.
Those cases have to be reported, correct?
Yes,
That's how they're initiated.
that's correct.
And would it be safe to say that in this case, the reporters, without any names, the reporters were,
Objection calls for hearsay.
Go ahead, finish your question.
reporters were not all the same?
That I wouldn't know. I'd have to go look.
Somebody asked in the chat who reported, who made these allegations, Colin 6-hitter, and I was waiting for the answer. And apparently it was not Ashley, more than one person. Hold on.
Do you have the reports with you?
I do have the reports with me. I don't know if it's going to tell me who the reporter was. Whether
Clicking something over here. If you are,
Huh.
please stop.
I don't
Go ahead.
want to know names,
Okay.
okay?
Somebody was clicking something, and the judge said, whoever's clicking something over there, stop.
The names are confidential, are they not?
That's correct.
Okay. I just merely want you to tell us whether or not, in fact, the reporters were different individuals. Would you search your?
I can look. I don't think the reports
Yeah.
are going to tell me, but
Judge already checked the hearsay.
The
But
photos.
now the question is just,
Whether the reports were from different individuals.
I think, Liesel, I think that her website is westandwithashley.com, I think.
It appears the report on 12/10/2019.
I just want to, because we're in a bit of a delicate area, Detective, I just want to establish whether or not, if in reviewing your reports, you're able to tell us if the reports were initiated by different individuals.
By looking at my reports, I cannot tell you that indefinitely.
Did you at any time personally interview Ashley Benefield?
I may have. I don't recall if I ever interviewed Ashley. I know I interviewed Douglas quite often. Initially, when I get these cases, the interviews with her were already completed. So.
Did you at any time personally interview the child?
No.
Never interviewed the child. He's part of the child crimes
I
against
don't believe
children
I have anything else. Let me
department.
just check you on. That's all you wanted. Thank you.
You're
It wasn't Ashley.
I believe you said, with respect to did you interview Ashley, that you said by the time it gets to you, a lot of times those interviews have been done.
That's correct.
And that would be by who?
Uniform.
Uniform. And then he asked, did you interview the child? Do you normally interview children?
No.
What is the protocol for children?
Forensic interviews are done by child protection team.
Okay. And so generally speaking, you wouldn't say you interviewed children?
No.
And was this child of an age to be interviewed anyway?
No.
Okay. No further questions.
Surely too. So who did you interview?
Sir,
That's all.
can this witness be released?
He's part of the
sorry.
crimes
Can this,
against children. He's a detective in the crimes against children department. The only person he ever interviewed was Doug. He never interviewed Ashley. He never interviewed the child. Did he even see the child? Did anybody see the child? So the only person that you interviewed is the person being accused by a couple of different people, it seems, of physical and SA of a child. And the only person that you interviewed was Doug many times. He said he interviewed Doug many times. Can anybody tell me what's wrong with that picture? Please drop it in the chat.
this witness
Yes.
be released?
Sorry.
Mr. Taylor, can this witness be released?
Yes.
Sir, you're hereby releasing your subpoena. You're free to go. Thank you. Thank you.
How
All right,
Cantonian,
you
someone
came
said.
back early. We went to an early lunch, so we got back a little bit early. It's now, I think, a good time to take our mid-afternoon break. It is
We might, oh, wait.
about 2:50.
We're way
So how
behind.
about we take, probably
We're way behind, so we can skip right through the break. Unless they're going to, let's see if they're going to argue something.
you have a seat.
Here's Jules.
Stay looking at the list in front of me. 1, 2, 3, 4, 5 more on the list.
Yes. Yes. Yes.
I have a question about that.
Yes.
So we've had Dr. Vega kind of on hold. And so I don't know how far we'll get with these next 3 witnesses. I can have him come here, but my question would be is if it was gonna take us past 5, if he comes, can we still do it? Because he's very busy and I hate to take up so much of his time. Or would Your Honor rather, because I know we want to deal with some other things, would you rather me tell him first thing in the morning? I know you don't know how long these witnesses are gonna come, take.
I can tell the court that Dr. Broder is going to be up there for a while.
And so I just don't, my question is, if I have him come, can we deal with him today? Or do you think once we hit
Deal
5
with
o'clock,
him.
if it's beforehand, you're gonna wanna go home? Which I understand either way.
Yeah, I would imagine that if it starts pushing 5 o'clock, we'll probably break and start again tomorrow.
Yes, sir. Okay. Okay, that's the schedule, that's all I have.
An attorney
Okay.
who wants to work past
I
5.
do have something else. If you don't.
Prosecutor.
Not
even.
as scheduling. So, the clerk was kind enough to unseal your order, but the items that were attached are evidently in that room locked up. And so I just don't know how we could get a copy because I haven't seen them. And so I just want to address it with the court of how to get a copy.
The evidence clerk is making copies.
Oh, good. Perfect, thank you. Thank you, Judge. Thank you.
All right, anything before the break?
Right.
Yes.
I'm so sorry, Monkey Biz, for you and your friends. That is devastating. We're now able to FF through the break. Anybody have one of those old-fashioned tape recorders? The rewind button and the FF button for fast forward. That's what I'm going to call it. FFing. We're going to FF through the break.
Fitz? All right, we're back on the record. State ready?
Yes.
Fitz?
Yes.
All right, let's go and bring in the jury.
Before we do that, I want to look at this. Double trouble. Thank you for the 5. Marsha Thompson had numerous witnesses that heard her husband threaten to kill her whole family, including her parents. She was acquitted. I have that. We watched them read the verdict yesterday, I believe. And I only had the shortened version. I have a longer version of it, but anybody who didn't cry when they read that verdict absolutely has no feelings. Thank you for that. It was a similar case in Palm Beach County. Marsha Thompson was physically and emotionally abused by her husband for over 20 years. She shot him while he was laying on the couch underneath a blanket. She was just acquitted a couple days ago, right there in Florida. So that is hopeful, anyway, for survivors. Pro Farrier, thank you for the 10. Love what you do and love the commentary. Keep up the good fight. That's all we're trying to do here, right? Like awareness, maybe some grace, some empathy. Innocent until proven guilty. Let's hear the whole story. The media has painted her out to be a monster. This case has been pending for almost 4 years. And I commend her for being able to keep her mouth shut and not going on TV, not giving any interviews and I see a young mother trying to protect her child. I'm obviously in the minority, obviously. Because if you see what's going on out there, you see that everyone thought she was a gold digger, manipulative. She intentionally sent the mother to the park with her daughter so that she could kill. It's like what's going on out there is insane. This is the first time her story is being told, and she hasn't even taken the stand. She hasn't even given a statement. We don't even know. The only reason we know her version of events is because her attorney put it in the motion to dismiss, which we went over during my pretrial summary of this case. I don't know if she's going to testify. Pilgrim Shadow, thank you for thanking the moderators with your 20. Thank you. You're very generous. Cheryl had one question. Did they say he tried to poison her with the tea before or after he sent a tea set? Well, she went into the hospital complaining that she had been poisoned in March of 2018. And that's when her baby was induced. Perhaps they wanted to test the baby for the heavy metals. And then he sent her the tea set in June. So it was March when she went to the hospital complaining about the poisoning. And then he sent her the tea set in June. So it was after. Wrestler's mom, thank you for the 5. Thank you for being the voice of reason. All the DV victims appreciate you and love you mucho. Right back at you, girl. Right back at you. All right. Well, the prosecution only has 5 more witnesses. They seem to think they're going to get to at least 3 of them this afternoon. They're going to wrap their case tomorrow. So this is a lot faster than I thought it was going to be. And I think that anybody thought it was going to be. So we're here for it. Let's keep on keeping on. And go. Crazy, Lauren. I don't get it. Benefield's second wife died, Tracy. His first wife, he married when he was 28. They were married for 6 months. His second wife, there were text messages. He kicked her so hard on their honeymoon. She died at age 56, face down in bed. She was found dead. Eventually, I think it was ruled a heart condition. But Ashley had questions about that too. She thought perhaps his second wife was poisoned. That's the mother of Eva. We're going to see how much of that is going to come into evidence. But yeah, she did.
Anything about the case or doing this?
You saw the swear affirm testimony that's agreed to be the truth, the whole truth, and nothing but the truth.
Yes, I do. Thank you. Oh, sure.
Good afternoon, Judge.
My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. You want to be about 12 to 15 inches from the microphone, so you can probably scoot up just a little bit. Adjust this left, right, up, down. And just using a loud, clear voice, it should pick up everything as we hear you breathing and breathing.
Fair enough.
Bless you.
Good afternoon.
Good afternoon.
Judge, just for the record, we renew all prior objections.
Yes, sir. The whole room.
Please state your name.
Brad Stephen Broeder,
How do you spell your last name?
Broeder.
What is your profession?
I'm a psychologist, clinical psychologist licensed here in the state of Florida and in New York State.
And how long have you been a clinical psychologist?
I got my PhD in clinical psychology back in December of 1986.
And when did you move to Florida? I think you said New York? You were in New York
Correct.
before.
I first practiced in New York and relocated here in the summer of 96. I was licensed here by February of 1997 and have been practicing here ever since.
Okay. And do you have your own private practice?
Exactly. I'm a solo practitioner.
Okay. Do you also do some, what I would call consulting work for the child protection team or child protective services?
Yes, I've been a consulting psychologist to the Sarasota County Child Protection Team since the summer of 1999, and several years later was hired as a consulting psychologist by Manatee Children's Services, which is their name for their child protection team. Pardon me. And recently have been contracted with the Fort Myers Child Protection Team. That's just as of this summer.
Okay. And can you just briefly explain what are your duties with reference to being a contractor for the child protection team? What do you generally do?
Well, through the Department of Health, each county in the state of Florida is supposed to have a consulting psychologist on their team. And that is for several reasons. One, it helps out with supervisory cases if on an as-needed basis, as well as once or twice a year, there's supposed to be in-service trainings where you conduct seminars, do presentations to help the staff there. But primarily it's to attend the multidisciplinary staffings, which they're asking the consultant to come in and discuss a certain case, what might be going on, if you have any kind of impressions or recommendations. Based upon those kind of meetings, then sometimes the psychologist myself would be asked to conduct an evaluation.
Okay. And ultimately, were you asked to conduct an evaluation of Doug and Ashley and Emerson Benefield?
I was specifically asked to conduct psychological evaluations on each of the parents, both Doug and Ashley, but not their child, Emerson.
Okay. The child was pretty young, correct?
2 years, 4 months to be exact, during the time I did the evaluation in the summer of 2020.
Okay, so you started the evaluation about when? You said summer, but
I believe it was June 1st to be exact when I first met Ashley, and the next day I had met Doug for the initial intake interviews.
okay. And what was the general goal of these interviews? You eventually were going to report back, I would assume, to the entity that hired you.
Yes, each psychological evaluation is meant to be submitting a report with diagnostic impressions and recommendations based upon the data that's been collected. The evaluation is based upon whatever the CPT recommendation was, meaning referral for the recommended evaluation. In this case, Manatee Children's Services had specific questions about each parent.
Okay, so and your evaluation is generally focused toward the best interest of the child. Would that be a correct statement?
Yes, absolutely.
Okay. So you said you first began this around June 1st of 2020.
That's correct.
Did you ultimately complete evaluations of Doug Benefield and Ashley Benefield?
Yes, I did.
Okay. And as part of this evaluation process, did you review documents?
There's a series of steps in any thorough psychological evaluation, which includes collateral data, which is both defined as interviewing other people as well as reviewing documents. Yes.
Okay. And did you do that? You reviewed documents?
If I may, I just brought the reports along with me in case I had to refer to them. But yeah, there was
Sure.
a series of documents reviewed for each of them.
Okay, and we don't need to get into specifics about what the documents were, but you did review several documents for each of them.
I certainly did, yes.
Okay. And what is a collateral interview?
That's when I asked each person to give me a couple names of people that they think understands their situation best that I could contact and call and just do kind of a phone interview. If possible, obviously a face-to-face interview is preferable, but based upon where people are situated and located, sometimes it's just easier to have that telephone conversation. So there are certain people, like the people through Manatee Children's Services, that I was going to be speaking to. For example, Kimberly Griffin, who is the case coordinator. But in addition to that, I asked both Ashley and Doug for their own people that they'd want me to speak to. But then, of course, doing the evaluation, I have the kind of wherewithal based upon what I learned from them, if there are other people I need to speak to or that I believe I should speak to in order to get a more complete picture of the individual.
Okay. And did you, in fact, do that with reference to both of them? Speak
Yes,
to collateral contact?
Yes, I did. Yes.
Okay.
Thank you to Sarah in shock and horror, the 25, who says, for current victims and survivors, you're not a victim for sharing your story. You're a survivor setting the world on fire with your truth. You never know who needs your fight or your light. You never know who needs your light, your warmth, and raging courage. We love you. You're the sweetest. Thank you for that. You never know who needed to hear that today. Thank you, Sarah. To Wrestler's mom, who says, thank you for being the voice of reason. All the DV victims appreciate you and love you, Mucho. Love you too. Back to Dr. Broder. Can't wait to see what knowledge he's going to lay on us.
Did you meet with Doug and Ashley and Emerson together or separate?
He never met with Emerson.
Given the structure of their family unit, I had multiple interviews with each of them individually. I had several interviews with them together, a couple of interviews with them together as the couple, but several additional interviews with them when they would exchange Emerson at my office, and when we would, kind of see how that the drop off or the exchange goes. But I had also seen each parent with the child, both in their residence as well as in my office. So there were multiple interviews.
Okay. So this sounds pretty extensive. So how much time did it go on over?
Throughout the summer of 2020, I think the report was actually completed and submitted on September 14th of 2020.
Why do I continue to ignore member chats, DJ Nashville? Did you send me a question that I didn't see because the chat's flying by and I'm concentrating on the testimony? I apologize. Would you like to put your question in here now? I'll wait for you. I'm not intentionally continuing to ignore anything. We're just watching testimony right now. So if you'd like to put your message in there, we'll wait. Do, 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 do. I don't discriminate here between members and non-members, so it's kind of a false allegation. Weird accusation, right? Are you still there? Okay. That was at 3:35. It's now 3:38. Still waiting. Okay. Guess it wasn't that important.
So I want to speak with you about Ashley specifically. Did she ever show any hesitation about meeting you with Doug present?
No.
Did she act differently when she was with Doug meeting you, as opposed to when she was not with Doug meeting with you?
As I had indicated or described in my report, she did demonstrate or present with a different demeanor when seen together versus when I would just see her individually.
Okay.
Maybe she was guarded.
And when you saw the two of them together, did they discuss the plans for going forward? And I'm talking about moving. So did they discuss that with you?
Ashley had made it very clear that she had every intention and desire to relocate back to her home state of Maryland. Doug had the impression that this was something that he too could do because he had some connections to the Defense Department and some of the work that he did. He felt he'd have more clients up there, so he was perceiving that as he shared with me, a fresh start that they could reconcile and be together in Maryland.
And when Ashley and Doug met with you together, did Ashley indicate that this was the plan, that they were moving all together as a group?
Ashley had no intention of moving together as a group. She had every intention of moving with her mother and Emerson and becoming situated in her grandmother had passed away and the mother had inherited the house. So they had their residence established. So she had that plan.
Okay. And so I guess I wasn't.
They're trying to insinuate that because Ashley was telling Doug that she wanted to reconcile when she really didn't, that somehow that makes her a murderer. Can anybody think of any other reasons out there in the chat land why she may be trying to appease him or keep the peace or something such as like that? I'm surprised that this doctor couldn't figure that out, but okay.
Being very clear, were they moving their items together, like same U-Haul truck?
How do you know? How does he know?
No, absolutely not.
Okay. So Ashley never told you about that?
Quite to the contrary, she made it clear that she did not want him to move in, regardless of what he thought or whatever he was planning. That was not part of the plan.
Okay. And that's why there was no reason for Doug to show up there and start loading up the pod or the U-Haul or whatever it was that was there, because none of his stuff was in it. They were not going to be moving in together, which is really, I'm here. Where are you? I'm right here. DJ. Hey, Mr. DJ. I'm right here. I can see you. DJ, you getting hangry? There was no reason for him to be there to help with the pod because he wasn't moving with them and he knew it.
And when she was alone, she would indicate to you those things that you just described?
Or
Yes,
did she indicate that when she was with Doug?
when she was with me during our individual meetings.
Okay. When she was with Doug, how was her demeanor? How was her attitude about those issues?
She would basically respond in a very deferential way. She would let him say what he wanted to say, but my focus was not so much on what their future plans were. It was, they weren't even officially divorced. My focus was, again, getting back to the point about the best interest of the child. Child protection team is, how do we get this family out of this stressful situation and then create something that's going to be better for Emerson.
Okay. Did Doug, during your
Was he trying to do that? Was he trying to help the family, or was he just trying to render a report back to the court? Because wasn't that his role, just to render a report back to the court because it was a court-ordered evaluation? Am I missing something here? I don't think that he was. That's why there's no patient doctor privilege here. Huh.
your joint sessions, did Doug express in front of Ashley that his hopes that moving forward, this was going to be an attempt at reconciliation? Did he express that in front of Ashley?
Yes, he did.
Okay. Did Ashley ever correct him and say, whoa, wait a minute. No, we're not doing that.
Not really. I think the closest she ever got to that was to kind of say, just kind of slow it down and, we'll talk about that later. And that's, that kind of thing. She would kind of deflect attention away from that.
Okay. And did she ever say in one of her individual sessions with you, did she ever say anything to you about she was running out of time and needed to move to Maryland or something like that?
Leading.
Do you
A little bit of leading there.
recall?
Yes, we had that discussion in one of the sessions.
And can you just explain what she said about that?
In essence, she was very frustrated and concerned that
I'm not going to object to, as I understand that he's called as a fact witness and he's giving opinions.
Yeah, he said, in my opinion, he's called as a fact witness that he's giving opinion. We don't really know what Doug did for a job, Coffee Nut. That's a great question.
Okay, you can answer the question. What was it that she said about the issue of running out of time and wanting to move to Maryland?
she was openly sharing with me her utter frustration with the sheriff's office, with CPT, with the court system, indirectly with myself, although she had also complimented me by thanking me for doing a quote unquote thorough job. But who was going to look out for Emerson, who was going to help Emerson, and she needed to do something. She needed this to be over with so she could get on with her life. She used the phrase, "My life is in a shambles."
Okay. And did she make any statements to you about why she needed this to be over so quickly? Or why was it, did she feel it was taking too long? I guess should be my question.
She certainly felt it took too long and she just wanted to get on with her life.
Okay.
Is that uncommon? Is that really that out of the ordinary? Dr. BROEDER? She thought it was taking too long. The wheels of justice turn quite slowly. I would have to explain that to my clients all the time. Never quickly enough. She wanted to get on with her life.
Did she admit to you that she was in fact going to marriage counseling with Doug?
She had been in agreement with them starting with a second marriage counselor, Dr. Quintel, after their attempts at marriage counseling with Sharon Foster had not worked out.
Okay. So she indicated that their intent to go to Dr. Quintel. But during the same time, was she still saying they would not reconcile, or she was saying they did want to reconcile?
I don't think she ever used the word reconcile when with Doug. She clearly made it very clear to me that she had no intention of reconciling.
Okay. And during this time, I would say the year at least before your meeting, did Ashley talk to you about doing things with Doug? And for instance, I'm talking about lunch and activities. Did she talk to you about that?
Throughout the time that I worked with them, it was very clear they were very open, sharing with me the things that they would do together, such as For example, the hit movie that particular summer was the sci-fi thriller Tenet, T-E-N-E-T, and they had agreed to go see that so the grandma could watch Emerson. They have a quote-unquote date. They enjoyed the movie so much, but also found it kind of confusing, hard to follow, that they agreed to see it a second time together and had a follow-up date for that movie. But in addition to that, they had done other things. She would go to Doug's apartment complex where they could use the community pool and take Emerson into the pool. They shared with me that they had gone to the beach. She described in detail watching Doug, I think it was Father's Day specifically in my notes there, where she described how nice it was to see Doug playing with Emerson, playing in the sand with Emerson. And so then from there, they would go out to lunch or go out to dinner, sometimes with Emerson and the grandmother, sometimes without. So they were, throughout the time I was working with them, they were seeing each other.
Okay. Did Ashley ever talk to you about the birth certificate for Emerson?
Naturally, in this kind of evaluation, since it concerns a child, they talk about the child and the marriage and the relationship and see each parent with the child. So yeah, that came up. She gave birth at Tampa General Hospital and signed the birth certificate, Emerson Grace Caney.
And do you know whose name Caney is?
She wanted to keep her grandfather's family name, and so therefore she used that name.
Okay, so the child wasn't named Benefield.
Was not.
And did she ever put, or did she indicate to you whether she ever put Doug on the birth certificate as the father?
She did not. That became a point of contention for the two of them, things that they were discussing, changing the name from Emerson Grace Caney to Emerson Caney Benefield. That was an issue that they were discussing.
And did she ever admit to you that she didn't tell Doug that she was even giving birth?
She shared that she did not inform him.
Okay. And you mentioned a little while ago that she was frustrated with some of the agencies. I think you said law enforcement, the courts, that kind of a thing. Did she express why she was upset with them?
She felt that Doug was unfit to parent Emerson, that he was only using the child to get her back, to win her back, so to speak.
Okay. And these agencies, they played into that, or they didn't play into that?
What was described and came out of our discussions in the interview sessions was that she felt that no one was willing to step forward to protect Emerson, that they all got it wrong, for example. So when CPT evaluated the situation where she had bruising on the neck, she described to me that it was several days later, so the bruising didn't show up, and that went down as unsubstantiated, so it was never followed up on. And
okay, so she basically felt like they were getting it wrong.
She was kind of right, though, wasn't she? That nobody followed up. She was kind of right. Okay, now I can't unhear her saying, okay.
These agencies were getting it wrong.
No one was protecting Emerson. She did not agree with that.
During one of your last meetings with Ashley, did you have a conversation with her in your waiting room?
The day after, a day or two after the report was submitted on the 14th, Ashley showed up in my waiting room, unexpected, unannounced, and she wanted a copy of the report. And I had explained to her procedurally that the work product that I produce is then the property, in this case, of Manatee Children's Services, and had submitted to them. But I let her know that, she'd be able to get a copy through her attorney, but they did have to get a court order to release it. And that's usually what happens. It's kind of a formality, but it's no longer something for me to share or divulge.
Okay. And did she have a reaction to that?
Her reaction was that she felt, again, very frustrated, thwarted in her efforts. She wanted to get on with her life, and she felt, she needed to know what was going to be recommended so she could move on.
Okay. And during that conversation with her, did she say anything that, that struck you as interesting during that conversation with her?
Interesting.
Well, she had explained previously and then repeated it then that once she was able to relocate to Maryland, she wanted to establish residence, as she had, in essence, researched it, knowing that if she had established residence for at least 6 months, she could then appeal to the authorities in Maryland to get relief and have Emerson, basically have full custody of Emerson and not that. So she had used the phrase during that conversation that she would take matters into her own hands.
Okay. And did she
Oh, so she was plotting to move to Maryland to get jurisdiction there so she could get custody, and that's what you're testifying to, Doc? Gator Gal 65, sorry to keep asking, but is this the doctor she moved in with? No, she moved in with the female social worker that testified early this morning. If you didn't watch that testimony, it's in the morning stream. She did not move in with this doctor. Okay. She was being open and honest with this doctor / evaluator / psychologist. But now it's going to be used against her as a motive for murder. Okay.
she express to you at that time about being frustrated about the timing, things weren't going fast enough?
By that time, she was, again, ready to move on, and she was frustrated with the entire system.
Okay.
Anybody out there
And
ever
did
been
she make
involved in a family court matter, divorce, custody? Sometimes they go on for 10 years. Ask Bethany Frankel. She talks a lot about her 10-year divorce. Everybody wants it to move more quickly, doctor. That doesn't mean that you go out and kill someone because it's not moving quickly enough.
Any more statements to you at that time?
Not that I recall. Again, I tried to encourage her to be patient, that her attorney would definitely be able to get a copy of the report, and they could, work things out once they read the report, and they should be able to settle things.
Okay. And did she ever say what she would do if it wasn't fast enough?
No, I don't think she specified anything more than her desire to, again, get on with her life.
Okay. When was the last time that you saw Ashley? Was it that day that you're talking about?
When she came to the office unexpectedly, yes, that was the last time. Prior to that, the last time I actually saw them was, I saw Doug on September 7th, and then I believe I saw them together on the 10th of September.
Okay. And the last time that you saw them together, how did they seem? Did they seem the same as they had the times that you had seen them before?
Well, Doug too is becoming frustrated because he was viewing this as a fresh start, as I said, and
Sustained.
Okay, I'll move on. Did you complete the report for Ashley Benefield?
yes,
And how long was that report?
27 pages.
And did you do the same type of a report for Doug?
Yes,
And was it about the same length?
I think 24 pages.
Okay.
Okay.
I'm sorry, 25 pages.
Okay. And I think you already explained this, but you turned your report over to CPT when?
September 14th.
September 14th. Okay. And then what happens to it after that is not in your hands.
It is, sometimes I find out, sometimes I get feedback, sometimes I don't. It's the work product goes to, in this case, Manatee Children's Services. And
Okay. And did any of your evaluation or contacts give you any concern for the safety of Ashley or her child going forward?
Their original marriage therapist, Sharon Forrest, had concerns. She certainly expressed concerns, yes.
Did you have any concerns? Well, let me ask you this. Did Ashley Benefield ever say to you that Doug physically harmed her?
No,
Did she present you to you as being fearful for her own safety at the time she was having sessions with you?
Her concern was all about the safety of Emerson, not about herself.
Okay.
Wow. Well, that's telling. He also never did physically abuse her until that day. That's already been brought out in testimony. So she didn't lie. She was concerned for the safety of her daughter. Like, that's a bad thing. He body checked her a couple times on the day of the shooting. He jammed a box into her. And then he punched her on the left side of her head, causing it to swell. And we heard testimony this morning from the social worker who saw the swelling to her left eye and the left side of her head. And that was the first time he ever laid hands on her, but how many times is enough?
Thank you. Any other questions?
Excuse me.
Cross?
Give me just a moment, Your Honor.
Thank you, Midnight Mike. Where a guy can go up in a second and destroy things, etc. Not a place for a child. He had shot a gun into a ceiling. He had thrown a loaded gun at her another time into the wall. He had punched holes in the walls. He punched the dog so hard that the dog was rendered unconscious. And then he threw the 13-pound cat against the wall.
Dr. Broder, good afternoon.
Good afternoon, sir.
We've met before.
Yes, sir.
Your history in this case has wound its way through to where we are today, and it's encompassed prior proceedings, has it not?
Yes.
Okay.
Yes.
And you've had occasion to sit for a deposition in this case,
Yes, correct.
and you've also given previous testimony.
Twice before in the
All right.
dependency
Don't
case.
tell me where.
Okay.
So you've told us that Ashley would act one way when she was with you, but she would act differently when she was with Doug. Correct?
Yes, that's correct.
All right. And your conclusion that you reached was that she would appease Doug. Was that not the case?
Ashley had shared with me a number of times that she felt the best way to keep Doug at bay so he wouldn't hurt Emerson was to kind of appease him, to kind of go along with him.
Yes, in your words, I believe in your report.
And how does that help the prosecution's case? Exactly. How does that help the prosecution's case? That she's saying the best way was to appease him. Oh wait, I just got to see what the law and chat crime is saying. I can't because it's kind of blurry. Let's listen to that again because that's important testimony.
Your conclusion that you reached was that she would appease Doug. Was that not the case?
Ashley had shared with me a number of times that she felt the best way to keep Doug at bay so he wouldn't hurt Emerson was to kind of appease him, to kind of go along with him.
Yes, in your words, I believe in your report, go along, get along.
I believe that's correct.
Correct?
Yes.
And that would be especially the case when Emerson was involved.
Yes.
All right. So, for example, if she didn't particularly want to be in
For example, why? It's part of his. You called him as a witness, ma'am, counselor. This is your witness. He's allowed to testify about his opinions, his report, his conclusions. Just because you don't like that he's saying that Ashley thought she needed to appease him so that he wouldn't hurt Emerson. That hurts your case, doesn't it? We can FF all the way to the end of this. Look at us catching up to real time. Got a couple of rants today, put us a little bit behind. Lots of conversation, chat, a lot of really good questions and comments.
So I think you told us, Dr. BROEDER, that this policy of appeasement was designed by Ms. Benefield to basically placate Doug Benefield.
I think I would use the word strategy. That was her idea of trying to.
Yes, to placate him. In other words, to not set him off.
She knew that she wanted to reconcile, so she wanted to kind of, I think, feed into that so he wouldn't, given her belief that he might hurt Emerson.
Okay. And you, did you decide whether or not the signs were there, but that Doug Benefield refused to recognize them? That she wanted no part of a marriage to him?
Let me make sure I understand the question. Are you saying, did I discuss with him about the signs?
Did you acknowledge during the course of these evaluations that the signs were there that Ms. Benefield did not want to be in this relationship with Doug Benefield, but he misinterpreted them and insisted on trying to be with her?
Unlike therapy and evaluation, you're constantly generating hypotheses, meaning asking other questions to make an assessment of the overall situation, different than a therapeutic relationship where you might be making interpretive statements and recommendations.
Well, let me ask you this. Did you consider that Ashley's position was that Doug was only interested in her and not in the child?
I certainly considered that, yes.
And that was Miss Benefield's position, was it not?
That his sole aim was to win her back, yes.
That he did not take interest in the child. He only wanted Ashley back. Thanks, Michael.
The abuse complaints, without giving me names, they were initiated by more than the same person, correct?
Correct.
In fact, there was
Objection herself.
Finish your question.
In fact, there was at least 3 different sources.
I'll overrule. Go ahead.
I believe there were 3, correct.
And 2 of those sources were professionals.
Sustained.
Wow. 3 different sources of the abuse reports on the child, Emerson. They've already named her a million times, so her name's out there. She's the 6-year-old that you see outside holding a sign that says, I forget what the sign says, but she's out there with the supporters who are speaking out against DV and believing victims. And 3 different, my freeze frame game is on point today, huh, guys? 3 different sources of the physical and essay complaints that were complaining about Doug abusing Emerson, the daughter, who I think at the time was 2.5. 2 of them were professionals, meaning mandatory reporters, likely doctors, teachers. Everyone assumed that it was Ashley making false complaints, because I think eventually we're going to find out that these complaints were dismissed or unfounded or never investigated, or somebody's saying there's photos of the child's injuries. I haven't seen them anywhere, so I don't know. But we're learning now that it wasn't Ashley who made the complaints. It was 3 different people. 2 of them were professionals. So let's just listen back to that. It was objected to and sustained. They've had pretrial rulings on this, but the jury's heard it.
Finish your question.
In fact, there was at least 3 different sources.
I'll overrule. Go ahead.
I believe there were 3, correct?
And 2 of those sources were professionals.
Sustained.
She expressed to you that she not real frustration with the system and its responsiveness to her situation.
Yes, she did. She was very forthright.
And she told you that with respect to taking matters into her own hands, it was going to be by virtue of her going to Maryland and petitioning the authorities there.
My concern was that she was going to impulsively abscond with the child and go to Maryland and yes,
Abscond?
establish residence separate and apart from.
She was not absconding. He was going to move there too. They just weren't going to live together. She was not absconding. That's the worst choice of words, doctor. She was moving to Maryland because her mother inherited a house there, the house that her mother grew up in. They were moving there to that house, and Doug decided he was going to move there too because he told somebody he got his dream job. I think that was his attorney, Stephanie Murphy, who testified about him getting his dream job in Maryland. So he was going to move there too because he was still chasing her. She wasn't absconding anywhere. She couldn't escape because he was going to move there too. Let's do that again.
My concern was that she was going to impulsively abscond with the child and go to Maryland and yes, establish residence.
Impulsively
separate and apart from
abscond?
Doug.
Okay, that she would have access to the authorities there, that they might be more responsive.
That was her hope, her goal. Yes.
All right. Are you familiar in your practice with domestic violence?
Yes.
Have you treated it before?
I've assessed it and treated it on occasion. Yes.
Treated it only on occasion. Huh. It doesn't sound like he's very well versed in the subject, but I don't know. So that's interesting. Oh, again, my freeze frame on point today. He reminds me kind of Yul Brynner a little bit. And The King and I.
Did Douglas Benefield, from what you learned as a result of your involvement in this case, exhibit
Objection.
Couldn't finish your question.
symptoms consistent with the domestic violence abuser?
Sustained.
Give me a minute, Your Honor.
Oh, wow. Thank you, Sinbad 333. There are reports that the child outside is not Emerson. Ask Jules when she comes on tonight. I don't know. This was the child that was outside prior to the trial, days leading up to the trial. But she held a sign about my mother. So I don't know. But that'll be great. Thanks. Oh, Sinbad, thanks for gifting a membership. You're so nice and sweet. Thank you.
I do have one other area of inquiry, if the court will allow me. Did you find anything aggressive about Ashley Benefield?
No.
Wow.
Did you find that Ashley Benefield had any impulse or was prone to angry outbursts?
Well, that's two different things, impulsivity and angry outbursts. I did not find her to be having angry outbursts, no.
Wow.
In fact, concluded she was good mother.
Yes, I observed her many times.
That's all. We'd like to keep Dr. Broder under subpoena.
Wow. And that is in direct.
You're familiar with mandatory reporting laws, right?
Yes, ma'am.
And what does that mean, mandatory reporter?
The mere suspicion of any kind of abuse towards a child or an elder, as well as domestic violence, needs to be reported.
So if someone goes to their child's pediatrician, or someone comes to you as a doctor and alleges abuse, what would you have to do?
I would have to report it.
Thank you. No further questions.
I'm going to guess it was one of the pediatricians.
Doctor, at this point, we're done asking questions. However, as you've heard, you remain under subpoena. The rule of sequestration has been invoked in this case by the parties, so that means you cannot discuss your
FF
testimony.
a little bit. See if they have any more witnesses today. They do. And here he is. Let's just break for a second to talk about how this Dr. Broeder's testimony was in direct contradiction of I got to find his testimony now. The DV investigator for the Manatee County Sheriff's Office of 22 years, Chris Gillum, who said that she was hysterical and aggressive, called him an a-hole. That was him, right? Chris Gillum. Having a meltdown. She wasn't getting her way with me. She was becoming aggressive. Well, not according to Dr. Broeder. Not according to Dr. Broeder. She wasn't. In fact, she was a good mother. So there, Detective DV investigator Gillum, who didn't want to believe a thing that Ashley said and didn't make a supplemental report until after he thought that, Ashley would be a threat because there was a death.
Thank you.
Hello, sir.
Hi there.
My name is Judge White. I'm presiding over this case. As the deputy may have said, just make yourself comfortable in that chair.
Okay.
You'd end up wanting to be about 12 to 15 inches from the microphone. It adjusts up, down, left, right as you need.
Okay.
If you're just speaking a loud, clear voice right into that microphone, it'll pick up everything.
Okay, great. Thank you.
Good afternoon.
Hi. Sorry, I spilled water.
It's already spilling things. It's all right. I do it every day. I dump
Please
my iced
state your
coffee on
name.
the carpet.
Dr. Jason Quintel.
How do you spell your last name?
It's Quintal.
What is your profession?
I am a mental health counselor
How long have you been a mental health counselor?
since 1998.
And where's your office?
My office is in Lakewood Ranch, off of State Road 70.
And how long have you been there?
That location we moved into in 2018. Prior to that, we were on Lena Road from 2008 on, and then prior to that, 2006.
And at some point, did you become familiar with Doug and Ashley Benefield?
Yes,
And when was this?
that would have been in 2020.
And do you recall about when in 2020 that was?
They came in for their first visit as a couple's visit on 7/15/2020.
Okay. So we heard from Dr. Broeder, he was talking about his goal was to do an evaluation. What was your goal with meeting with them? Was it an evaluation or something else?
No, I was referred by another therapist to do trauma resolution treatment for both Doug and Ashley.
Okay.
Yeah.
And as part of that, did you meet with them together as well as separate, or how did that work?
I did. I met with them originally as a couple. We ended the treatment as a couple, and then there were individual sessions in between.
Okay.
Okay.
I won't hold you to this, but about how many times did you see them?
So I met with Doug twice individually, Ashley 5 times individually, both of them as a couple twice. There was a total of 4 hours for couples, 10.5 hours for Ashley, and 4.5 hours for Doug.
Okay. And at the first session, did it seem to you as though, let me back up. The first session, was it together?
Yes, it was.
Okay. And during that first session, did it seem as though they wanted to work things out?
During the first session,
Okay.
they talked about, yes, they wanted to work things out.
Okay. When they were together, did they indicate they wanted to get back together, like reunify?
The goal was for them to reunify and moving to Maryland.
Okay. When Ashley met with you by herself, did she still make that representation?
That they were moving to Maryland, yes.
Okay. And was there anything different about her representation?
Ashley was different when she was separate from Doug in terms of more descriptive of things that had happened between the two of them that troubled her. So some stuff that was scary.
And we won't get into specifics, but
Ask the question, he's entitled to complete his answer.
That's right.
so did she indicate she still wanted to reconcile with him when she was
Yes.
with you alone? Did she say she wanted to reconcile with him when she was alone with you?
Hold on. Let's take that back because he said there were some scary things that happened. And the jury heard it. So we're going to hear it again.
That troubled her. Things and she was separate from Doug in terms of more descriptive of things that had happened between the two of them that troubled her. So some stuff that was scary.
And we won't get into specifics, but
Ask the question, he's entitled to complete his answer.
He's not letting him answer.
so did she indicate she still wanted to reconcile with him when she was
Yes.
with you alone? Did she say she wanted to reconcile with him when she was alone with you?
So I don't recall whether she said she wanted to reconcile with him or not. I think that there were challenges in their marriage and she was questioning whether she wanted to be with him or not.
Well,
Did Ashley tell you that she and Doug were also seeing Dr. BROEDER?
They both mentioned that Dr. BROEDER was doing an evaluation, and I didn't know what it was regarding.
Okay. And did Ashley say to you at any time that she was frustrated with the system?
I think Ashley was discouraged. There had been many things brought up, accusations, CPS, judge, that didn't go her way. So I think there was definitely some discouragement with that.
Okay. And I'm sorry to cut you off.
No, you're fine.
Did she express any frustration at the time it was taking for Dr. BROEDER's report?
Yeah, she thought that that was taking a very long time.
Okay.
okay.
And did she express to you that she was worried about what his report would say or worried about when the report was released?
She was worried about what it would say. She said if it were to be disparaging of Doug, she was concerned that he would be upset and take some form of retribution with that.
Okay.
Wow. Okay. Well, can you see that? Can anybody understand that? She said that if the report was disparaging to Doug, she was worried that it would be released because he may do something. Let's listen to that again.
And did she express to you that she was worried about what his report would say or worried about when the report was released?
She was worried about what it would say. She said if it were to be disparaging of Doug. She was concerned that he would be upset and take some form of retribution with that.
Okay.
Some form of retribution, like beat her, kill her, come after her. Okay, so you're only proving the defense's case even more. Prosecutor. Retribution.
The last time that you saw them was when?
The last visit was on 9/25/20.
Do you remember what day of the week that was? You might not, but.
Maybe Thursday, Friday. I can look if you need that.
No,
2
that's
days.
okay.
Okay.
And
2 days before the shooting. He saw them 2 days before the shooting. Did she tell you she was going to kill him? I want to know that answer.
about what time of day was it?
I believe that was a morning session, 10:30-ish.
Okay.
Okay.
Did they say Dr. Broeder's report was done?
Done.
I don't recall them saying that the report was done. I know that they had been waiting on it, and it was supposed to determine specific things for how they move forward.
Okay. And did they indicate when they were going to court next?
I do not know that. I don't recall anything mentioned
Okay.
about when court was.
Did they indicate to you when they expected they were going to have access to that report? Excuse me.
No, I don't. There was not a when the report was going to be released. It was going to happen at some point. My understanding is that they still had plans to move to Maryland.
Okay. Thank you. I have no further questions.
Okay.
Okay, so he did nothing to prove your theory of the report was coming out on the 30th, and that's why she killed him. This reinforces the theory that if that report was derogatory in any way to Doug, she was afraid of retribution from him.
Cross.
All right, I heard the cross is spicy, so even though people didn't spoil, they gave us, told us to pay attention.
Afternoon, Dr. Quintel.
Hi.
How are you?
I'm doing fine. How are you?
Good.
Oh, he seems like a pleasant guy.
So tell us why, when you met with them, Ashley was different when she was alone and when she was together with Doug in meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no.
Sustained.
Prior acts of violence. She was afraid of him.
Okay, without. Yeah. Oh, you have no idea.
Oh my gosh,
Why
that
don't
was
you go
great.
ahead-
Did you hear that?
Deputy, would you please go ahead and take the jury out?
Wow. Wow. We got to rewind that. That's what we do here. This mental health counselor wants to tell Ashley's story, and he's being handcuffed by the judge and by the pretrial rulings. And he wants to talk about the prior acts of violence and why Ashley had every reason to be afraid of the retribution. And he sighed and laughed because he was like, I really want to tell you. And the defense attorney, Neil Taylor, said, you have no idea. And now the judge is mad and he sent the jury out. Listen.
In meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no.
Sustained.
I'm not going to give you this.
Okay, without. Yeah. Oh, you have no idea. Without.
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out?
Wow.
Remember, please don't begin your deliberations. You can use your phones, but don't talk with anybody outside of the jury. And don't do any research on the people.
Sending the
places,
jury
things,
out
and
so
legal
he can
topics you've heard
reprimand
anything
Mr.
about.
Taylor for saying you have no idea.
Dr. Quintel, I'm going to excuse you to the hall room.
Okay. Take my stuff with me.
Yes, sir. The rule of sequestration has been invoked.
I don't even know what that means.
That's, I'm going to.
Okay, sorry.
I mean, that was just an excited utterance.
What that means, sir, is that you're not to discuss your testimony or the questions that have been asked of you here in the courtroom. It also means that you can't touch.
All right, let's let him go and then see what happens. We got to wait for him to walk out.
I'm not quite sure why, but about to catch a.
I being speaking. Mr. Taylor, is there anything you'd like to share before I begin speaking?
Anything you'd like to share?
I think I'm about to catch a whooping. I'm not quite sure why, but go ahead.
I believe that you expressed you're a veteran of over 400 jury trials.
Yes, sir.
This is all rhetorical. You can feel free to answer or not answer. My assumption is that you're familiar with trial process and procedure, that you're familiar with, as you had mentioned earlier, the rules of professional conduct and decorum. I'm also sure that you realize that if this court makes rulings that you disagree with, whether it's a passing disagreement or a fundamental disagreement with a ruling, I would imagine you're aware of the fact that if ultimately your client is convicted, either you or another attorney or a public defender, if she's indigent, will have every right to appeal to the Second District Court of Appeal every decision I've made. From the minute I sat down in this division and started making decisions in this case, all the way through the end of the case. I also would imagine that I'm not the first judge that has made rulings that you disagree with. I would imagine I'm not the first judge that you have looked at up here and said, where in the world did he or she get that from? I would hope that you have not engaged in the conduct like you just did. It was inappropriate. It was unprofessional. We're going to take just a few minutes break. I have this position and I understand criticism.
I don't think it was personal against the judge.
That.
I really don't think it was personal against the judge at all. I think he was expressing his frustration that he's just not able to say a lot of things on behalf of his client that he wants to say, and that the witness is being, I really don't think it was personal against the judge. Tell me if you think I'm wrong, but I really don't think it was. I think he was just out of frustration. Like, you have no idea. Not that it was anything that personal. I don't know.
I have often said that I think my job early on as a youth sports referee and umpire prepared me well for the criticism that comes with the job. However, those sorts of side comments are just, they're not appropriate. And I would caution you, sir, not to do that again.
All right, just apologize.
That's extrajudicial matters.
Fall on the sword,
that have
Taylor.
Nothing to do with the case or the consideration
Fall on the sword, Taylor. Say, I'm really sorry, Judge. It won't happen again.
of the jury. All right. So we'll take a 5-minute break and we'll be back.
All right, everybody's going to get a little time out. I don't listen. I think he's frustrated. He's trying to represent his client. I'm sure that he believes that his client is innocent and has a self-defense case here. He feels like he's being hamstrung. The witnesses are being handcuffed. There's a lot of pretrial. I really don't think that that was personal against the judge. And I will tell you that if it was Judge Cannoni sitting on that bench, it would have been a lot worse. Somebody said that, yeah, Alan Jackson would have had to go get his toothbrush because he would have been spending the night overnight in the Norfolk County pokey. Yeah, the judge seems like the judge is frustrated too. Judges try and follow the law the best that they can. I'm going to cut this one a little bit of slack only because I didn't follow all the pretrial stuff. So maybe my opinion would be different if I did follow the pretrial stuff with you. I don't know that a whole lot of it was televised. Maybe some of it was. And it's unfortunate because I'm finding this case so interesting now that I'm invested in it for everyone, for the world to see. And they're already up at sidebar.
Said that he knew I couldn't.
Okay, hold on.
remind both, get him back after
Okay.
Quintel, get him back in here. As he's coming in, I want to remind both sides that the court has made a number of rulings over the last couple of months regarding the admissibility of certain evidence. Until those decisions and orders are revisited and changed, it is the responsibility of both sides not only to operate within those bounds, but also to advise their witnesses of the prior court orders and admonish them to stay within those bounds. All right, go ahead and bring in Dr. Quintel.
Stop. Everyone stop.
While
He's
you were
talking
outside,
horror.
did anybody attempt to discuss the issues we talked about?
I did not speak or interact with him.
All right, did that person ask you questions?
Wait, a reporter
In-
came up to
in-
him.
I did not
Wait,
speak.
what?
Or did you speak
What
with
happened to the
anyone at
reporter
all
that
about
came
your
in and wanted to
testimony?
talk to the judge this morning? And then the judge said you need to come back during open court. So come back at 12:30. And then the judge, the reporter didn't come back, alleged reporter. But wow, hold on. This witness, Dr. Quintel, is going to say that a reporter came up to him in the hallway. This is so interesting what's going on in Manatee County. I can't believe the courtroom's not more crowded. It is open to the public. If any of you are interested and want to watch it in real life, pretty sure you can get into the courtroom. Seems to be a lot of empty seats there.
All right, welcome back, Doctor.
Right.
While you were outside, did anybody attempt to discuss the case with you or speak with you? Or did you speak with anyone at all about your testimony or the issues we talked about?
I did not speak with anyone. There was a reporter that came up to me, but I didn't engage with him or interact with him.
All right, did that person ask you questions?
He said that he knew I couldn't talk, but here's a card. I said, I don't want that.
Okay, all right.
Ooh,
Anybody want to
Didn't
follow
want
up
it.
questions about that? All right.
Yeah,
so
who is
let's
it?
bring in the jury.
tell us. Oh, he didn't take the card. Somebody said that Ashley was on Good Morning America. Was that really this morning during this trial, or was that an old interview that they just aired this morning on Good Morning America? Does anybody have a copy of it? Can you email it to me? Fanbase@mlittlelaw.com.
All right, y'all can have a seat. Welcome back, everybody. Anybody begin deliberations, talk or communicate with anyone outside the jury about anything we talked about, or doing research? Everybody says no. All right, Mr. Taylor, you may resume your cross-examination.
Thank you. Doctor, did you, as a result of meeting with the two of them together and separately, did you reach any conclusions about the relationship?
Objection, relevance.
Relevance? He's a mental health counselor. He's supposed to be evaluating them for marriage counseling and domestic violence and child abuse. Is it not relevant? Oh, for the love of the traveling Mary.
Conclusions about the relationship?
Objection, relevance.
It's your witness. Judge,
All right,
come
you
on,
can
Judge. Wait, what did he say? Conclusions about the relationship. It's a very broad question. You're out of order. You're all out of order. Right? How is the relationship not relevant? We're not in real time yet, are we? Oh my God, a judge that works past 4:15. I'm shocked. I'm shocked.
Conclusion.
You, I'm not.
Wait. Okay. Okay, everybody say hi to
Did you
Karen.
make it?
Everyone say hi to Karen Kruger. She's a bit scared to be in chat, had 3 wild experiences in different chats with this trial today. Seems safe here. Everyone say hi to Karen. Karen might be on our team, my friends. Karen, I'm really sorry for what you had to go through today. We're all really sorry. I'm glad you found us. I think you can take a breath. My mods are the best on YouTube, and we're not going to tolerate the vitriol, hatred, and insanity that is going on out there in the other chats. So welcome, Karen.
Any inquiry, doctor, about why Doug Benefield would want to stay in this relationship?
Objection, Hussein.
Oh,
Good. Why does Doug want to stay in the
You can
relationship?
answer.
He
Can you
wants-
repeat the question, please?
he
Yeah.
wants to
Thank
talk.
you.
Wants to talk. Yes.
Was
Would
there
you?
any observation by you in response to why Doug Benefield would want to remain in this relationship with Ashley Benefield?
I questioned why both would want to stay in the relationship, but specifically to answer the question with Doug, I did bring that up in a session, that it seems like Ashley is saying very disparaging comments, and I'm not sure why and what you see in that ongoingly moving forward. I did bring that up to him.
In fact, you were perplexed by it, were you not?
I was confused, sure. It did, yeah.
Would it be a fair conclusion to say that he was hell-bent on staying with her?
I would say that he really wanted the relationship to work from everything that he told me.
Okay. We're going to have to recall you, so I'm done.
redirect? No. All right, sir. So at this point, you are going to remain under subpoena.
Okay.
You're free to go now, but one of the parties, one or both the parties, may actually call you back later. So all those instructions I gave you earlier still apply. Don't discuss your testimony with anyone, even the attorneys, any other witnesses. You can't watch anything that might be online or reading.
I want to hear the last sentence again. He was perplexed why Doug wanted to stay in the relationship because Ashley said disparaging things about Doug.
Conclusion to say
He was
that he
hell-bent
was
on staying
hell-bent
with
on
Ashley.
staying with her.
I would say that he really wanted the relationship to work from everything that he told me.
He really wanted the relationship to work.
Okay. We're going to have to recall you, so I'm done.
Redirect? No. All right, sir. So at this point, you are going to remain under subpoena.
Okay.
You're free
Right.
to go now.
They're free. They're likely going to recall him during defense's case in chief.
Approach about scheduling.
Okay. The attorney quite a while. All right, members of the jury, the next witness may take quite a while. So instead of keeping you so late tonight, the attorneys and I have agreed it's probably better to just come back tomorrow morning and start fresh. So I'm going to let you go for now. If you would please say tomorrow time. Are you guys okay with the time?
Yes.
All right. Let's again plan. What would we say today? 8:45, and get you up here and hopefully get started right about 9. So let's do the same thing tonight. Please remember, no discussion amongst yourselves. Talk about the weather, nothing else. Don't talk about the case
Talk
with anyone.
about the weather.
And then the clerk, we got the copies of the, when you unsealed, we got the copies of the, I got the original order that you did, and then the clerk provided me the transcript and the emails. I think you said something, when you said transcript, was that the transcript you're referring to? Because the court order hasn't transcribed what happened.
Correct. I sealed, if you look at my order, I sealed her raw data, her notes, and any transcripts.
Okay, so I was gonna ask her to do it, but I wanted to clarify before I did something wrong.
I have not requested it. I don't even know if one has been done, but it has been unsealed if there's one.
Thank you, sir.
Does your order, Your Honor, allow the clerk to give them a copy?
Yes. Everything's been unsealed.
If you guys watched this, because I cut it, I zoomed through it. I FF'd through it. What time did he tell the jury to come back tomorrow? Same time? How do you become a member? L. Parker, thanks for asking. There should be a join button right underneath the video. You might have to close out the chat because they keep changing the YouTube format. I'm not a fan of the new format. Maybe one of the mods could drop. If you have an iPhone, it's different. So maybe one of the mods could drop a link in there for you. But thank you, Elle, for even wanting to become a member. That is so sweet of you. Padeline Loon, thanks for jumping in from Canada to say it contradicts she planned to kill him if she planned to seek change of venue for her case. It's normal to ask for that when you plan to relocate. Great point, Padeline Loon. K Music Taylor, I definitely thought of shooting my ex. Okay, I shouldn't put this up here. He abused my kids and I had to watch and helplessly cry. I got out with kids but stayed sheltered several years. I'm so sorry, Kay. Love you. Sending 1,000 hugs. Kim, how do I become a member? Oh, thanks, Kim, for coming in from Canada and also wants to be a member. Oh, thanks, Scott Messerschmidt, for putting the link in chat. He just put the link in chat. You know what I'm going to do? I'm going to pin it. I'll pin it because I know how to do that. Oops. Instead, it took me to the link. Hold on one second. Okay, I pinned the message. So there's the link. Thanks, Kim, for asking. Carrie Ford, thanks for the 5. Did Doug just leave his daughter Eva in South Carolina when he moved to Florida chasing Ashley? That's a great question that I don't know the answer to. If anybody knows, you could tag Carrie Ford in your answer. I'd like to know that too. Maria says, Vinny had cousin Tommy on and played him the clip of the defense attorney calling him a creep. What? When was that? Oh man, we may need to stick around and watch some of these clips, you guys. Danielle, thank you for gifting a membership. You're so sweet. Jason, thank you for the 5. Judge needs to put his big boy panties on under that robe and man up. It was a joke to lighten things up. I know. They don't like the extra commentary. Sometimes they take it personally. There were some things that Alan Jackson said that he got chastised for too. Can't remember exactly what they were. More than once. Probably David Yannetti did as well. Borderline became a member. It's a great Madonna song. If you know, you know. Here's a great question from Laura. Laura says, are you saying that the jury may be old-fashioned or can older age be a benefit? I would love to hear from the chat on this. I have my own thoughts. We know there will only be 6 jurors deliberating in the final jury, which is weird but in Florida, unless it's a death penalty case, it's a 6-person criminal jury. And so there are 3 alternates. So there are 9 potential jury members. 7 of them are women, 2 of them are men. And we know from our eyes and ears in the courtroom that the women are 60s, 70s, 80s. And there's one man who appears younger to be in his 40s. And I would love to know what you guys think about that. I think that older women have experience. They've seen it. They've been through a lot of stuff. And I think that it may be helpful to Ashley. But you tell me what you guys think. There's also a generation ahead of mine, maybe, perhaps, women, wives, mothers who stayed in it for the kids. Nobody believed them. So maybe they might be a little bit more sympathetic to the defense. Nosy Rosie says, I'm concerned that an older jury might be old school with old beliefs. Does that make sense? It does. It does. I think it could go either way. Amy says, I think maybe the older generation saw a time DV was more accepted, so may be more aware of the pattern. That's true. It's true as well. Rocky says, I think they are mostly female jurors has more impact than their age. So you think that women would be more sympathetic to the defense or less sympathetic? Because a lot of the vitriol that we've seen, I'm sure Karen can tell us, she was in some other chats today that she said were horrific. It's mostly the women that are hating on the other women, victims and survivors. So I don't know. Coming from an old lady, we are a huge benefit. All right, Karen Durst coming in. Here's Karen A. Says, I'm thinking a lot of older women have lived through this during a time when you didn't speak up at all. Right, so is that good or bad? Good mix, experienced women, and hopefully a woke man. Thanks, Missy. Oh, you guys are moving so quickly. Hold on, I had a good one here about Southern women are tougher than you think. Where'd it go? Midnight Mike says, so much appreciation for all the courageous women in this chat. Men do care a lot. We are not all animals. Oh, thank you, Midnight Mike. Miss B says, this poor woman did everything she was supposed to do from a legal standpoint, and not one person believed her or helped her. Her hand was forced, and she did what she had to do to survive. Yeah. Coffee Nut says, I think Jackson said you should know better, something like that to Proctor. Yeah, he did, right? Shame on you. That's what it was. Shame on you, Proctor, says Thomas. Yep, shame on you. Shame on you, AJ said. Yep, that's right, you guys. But there were other times where he said things outside the presence of the jury when he was talking to Lally, or Lally even said something like, it was shameless, or they did something shameless, or I can't remember, but then he lost me after how he talked about Dr. Russell. Oh, you mean Dr. Russell because wasn't there another Dr. Russell this morning in this case? The social worker was named Dr. Russell that we heard from this morning? Barbara Russell? Are you talking about Dr. Russell in the Karen Reed case? People think it's going to benefit? Stephanie said, I was worried when I heard there were older women on the jury because they're old fashioned. Sarah says, the older I get, the wiser and cooler I get. Southern old women are tougher than you think. I think they're appalled at what Doug did to her. That's great, Courtney. That's a great comment. Coffee Nut says the older women will understand the abuse. They either lived it or saw it happen. Life experience. Mama Jamma says, I'm older. Many experience I have made me want to stick it to the man. She seems authentic. Thank you. Thank you for chiming in. Anna says, yes, but older women were used to sucking things up. Yeah, maybe now they're mad as hell and they're not going to take it anymore. Truth Seeker says, I think the older jury will be able to see through any possible baloney in this trial from the prosecution. Yeah, Jackson, maybe he said, of course, one time. Oh, thanks, Laura. Says, I love your earrings. My daughter would love them too. These are Steelies. I can't really see them too well in this light, but Grateful Dead Steelies. Thank you. Thank you very much. Speaking of Vinny Politan, I am in an unofficial subscriber competition with him that he doesn't really know about. So let's see where we stand right now. Right now, I'm at 65.2 thousand subs, and I think Vinny's at something like 70,000. So if you guys would just hit that subscribe button below, it's free. And that would help me in my unofficial competition that Vinny knows nothing about, of getting more subscribers on YouTube than Vinny. So thank you. Thanks so much. Mima says, I would never be a victim again. Now 71. Aw, thanks, Jill. Thanks, Jill. We got to beat Vinny. We got to beat Vinny. No, I'm not saying unsub from Vinny. No, I'm not saying that. I'm just saying. Okay, so do we have no, Monique, have I ever heard about Marianne Bachmeyer, a West German woman who shot and killed Klaus Grabowski for the murder of her daughter Anna in an act of vigilantism in 1981? No, I haven't, but it sounds interesting. Let's see if we can find the Good Morning America interview. Was that really this morning? Did she really go on Good Morning America? Yeah. Hold on. Wait a second. Wow. Wow. Okay. So let's watch it. You guys want to I don't know, Good Morning America gonna strike me? They might. They might actually. So how about if we put the link in here, you guys can watch it? Sometimes like KTLA even does that too. I'm going to put it in the chat so you guys can go watch it and then we can talk about it tomorrow. There it is. Go watch it in a few minutes, not just right now. Oh, so yeah, we didn't know about this carry forward. If anybody knows about that. But yeah, we can look at Vinny talking to cousin Tommy. So let's see if we can find that. Where would that be on the court TV? YouTube, maybe? Let's see. Is that during, there was a body language breakdown? Nope. Maybe I'll have to pull these things for us to look at tomorrow morning. Was it a trial day 1 recap? Hold on. Yeah, this looks like Vinny. Hold on. Maybe we can find it right here. That's a day 1 recap. Oh, he does have cousin Tommy goes on on day 1. What? Okay, hold on. Oh boy. All right, guys, buckle up for cousin Tommy going out and doing the media tour after day 1. I can't believe this is only day 2 of this trial. So it was yesterday. He went on court TV and did an interview with Vinny. All right. Let's watch. Thanks for telling me about it, you guys. Such a collaborative channel that we have here. All right, here. Let's see what happened here. All right. Hang on to your seats, folks.
Tommy Benefield also testified today, the first witness called in this case, and he's Doug's cousin, been very outspoken and really one of the driving forces to try to get justice for his cousin. How about that moment inside the courtroom?
He had a lot to say about their relationship as well, Vinny. And one of the things we've heard a lot about in this case so far is that both Doug Benefield as well as his wife, Ashley Benefield, both had a love for guns. And so this was a little bit of Tommy's testimony talking about where Ashley kept a gun. Let's listen.
Did Ashley ever discuss with you that she carried a gun?
Yes.
And what did she say about that?
She said that on their initial meeting, in the political meeting, that she and Doug's traveling partner in business went outside of Secret Service people, and she showed him the gun she was carrying at that event in her bra.
And that was the night they met. And then about 13 days later, they ended up getting married. This is Ashley and her husband, Doug. So interesting to see and hear what's going to happen as things transpire in this case, Vinny. And some late breaking word today, we heard this earlier, that the state is planning to rest on Thursday. So this case is moving a lot more quickly than we had thought.
Oh, it's super fast. You could tell. I mean, witnesses.
Are we not going to talk about the part where Tommy was cross-examined about how he was trying to get with Ashley even in May of 2018, told her she was with the wrong Benefield and that he was flirting with her? Are we not going to talk about that whole thing that happened in court, which showed his bias? Okay. And yeah, he called him a creep. Neil Taylor called him a creep, not to his face, that he was a creep when he was arguing that those text messages should come in. Wow, that part, yeah.
On and off, important testimony, important witness after important witness. And we could be in a verdict watch on Friday. So Kelly Craft at the courthouse. We'll speak again tomorrow. Thank you so much. All right. I want to bring in a special guest joining us. You saw him on the witness stand. He's been speaking to us throughout our coverage of this story. Doug Benefield's cousin and family spokesperson, Tommy Benefield, is with us.
Don't spoil it for us, you guys, because I haven't seen this yet, but does Vinny ask him the hard questions? Does Vinny ask him about the bro code and why he was trying to get with Ashley? And wow, okay. All right, I can't wait. Oh, thank you. For Ashley's interview was before the trial. You just watched it. Thank you, CJ's mom, for telling us that. Guys, don't leave now because you don't want to see this. I mean, you don't want to miss this. All right, cousin Tommy, this was yesterday after he testified. He's still under subpoena. He shouldn't be out there giving interviews, but I don't really know if he's not supposed to give the interviews, he's just not supposed to talk to anybody about the case, but he is talking about the case. So I don't know how he gets around this, right? Isn't he still under subpoena? All right, hold on.
Tommy, first witness on the stand today. Did you know that going in, and how do you think things went for you?
Hey, Vinny, thanks again for having me tonight and for letting us speak for our family and our side of the case. I knew I was going to be first up because of background, in particular because I had several weekends and several events with Doug and Ashley specifically, and that I ended up maintaining that.
Oh, Daniel, I don't think you're going to be happy here. Whoa, we're praising a woman who kills the man instead of reporting the abuse and leaving him now. Does that sound too far to anyone? I think you're in the wrong chat, sir. Sorry, Daniel, I think you're in the wrong chat. You might want to go over to Law and Crime or to some of the other creators because she did. So yeah, I don't think you're going to like it here, Daniel. Sorry. Hasta la vista, baby. Peace out. Let's go back to cousin Tommy.
Thanks again for having me tonight and for letting us speak for our family and our side of the case. I knew I was going to be first up because of background, in particular because I had several weekends and several events with Doug and Ashley specifically, and that I ended up maintaining that open relationship, open communication with her long after they separated, giving her a chance to voice her concerns and allegations all the way up until my deposition in 2018.
You supported her after her allegations of DV. You supported her. You told her she was with the wrong Benefield, dude. Now you're going to go on because your wife is mad about what you were doing. And now you're going to try and redeem yourself. Okay, good luck, sir.
I believe we had a good day today in the prosecution side of the presentation. This is still the state presenting their information all day today and into tomorrow. It was very, very clear where Mr. Taylor was trying to go in his part of the case. But I don't think that the case is going quite the way he wants to. We have the single events that Doug admitted to a long time ago, but we don't have any events ever accused of him or found true of him once Ashley moved to Florida. So there's a big difference between what happened in the home in South Carolina and then all the 2-3 years that they were in Florida off and on together.
There's a big difference?
Now, there was a moment today, and as I'm watching this, the jury's out. You're out of the courthouse as well.
Wait a second. Open relationship? Hold on a second. Let's go back. Thank you, Tonks, for pointing that out.
The single events that Doug admitted to a long time ago, but we don't have any events ever accused of him or found true of him once Ashley moved to Florida. So there's a big difference between what happened in the home in South Carolina and then all the 2-3 years that they were in Florida off and on together.
So because you're aware that back in South Carolina, he punched Sully, the family dog, so hard in the face that he rendered the dog, Sully, unconscious. You're aware of that because you testified about that. You're aware that he shot the gun into the ceiling, right? And you're aware that he threw a loaded gun at her and hit the wall. You were aware that he punched holes in the walls in South Carolina, but now you're getting on court TV to say you weren't aware of anything that happened after that in Florida. So, hey, it was way different in South Carolina. Way different. So, no reason to think anything was wrong over there. Dude.
Together.
Now, there was a moment today, and as I'm watching this, the jury's out. You're out of the courthouse as well. And her attorney starts talking about you because there's some dispute about some testimony that they're trying to get you to talk about. So I don't know if you've seen or heard this, but I want to play it for you to get your reaction. Here again is Ashley Benefield's attorney talking about you.
As succinctly as I can, Your Honor, he's a creep. He acknowledged being a creep, and the jury will conclude he's a creep. It goes directly to his character and his bias. And that's why, after he said, yes, it was accurate, I recall it, he cannot bring himself to say it. And the reason he can't bring himself to say it is because he knows that all these women on the jury are going to know exactly what he was referring to.
Look at Vinny stirring the pot. Look at Vinny stirring the pot. Do you think that cousin Tommy knew about this before this appearance last night?
Okay, so Tommy, I heard that, and folks watching heard that. I wanted to give you some time to respond because there's the rules of the court. You can't say everything you want to say on the witness stand. So give us your side, because this is all referencing text messages.
Hold on, here's DJ again. Hi, DJ. Hi, DJ. Look, I'm not ignoring your question. He did also slam the cat, the 13-pound cat, the family cat. And he didn't just slam it against the wall, he threw it against the wall. Yeah, he abused the animals too. He had never hit her or laid hands on her before, but how many times does it take, right?
You and Ashley, and in one of them, it's alleged that you said that, Ashley, you married the wrong Benefield.
That's not what the bubble says. It specifically said wrong Benefield. What I tried to do was give it the context appropriate to what Ashley has said in the text message prior to that. And of course, he's painting it the way he wants to. I've never in my life ever been accused of anything that he accused me of today. I was answering that what she was looking for in conduct, that there were different Benefields, and she was talking about the wrong Benefield, the wrong behavior. And I've never been accused of being a creep. Everyone in my company, ever in my business, everywhere I've ever been, no one's ever accused me the way he did today. Disgusting is my point of view. I was out of the room for it. My family and I talked about it this afternoon and this evening. But the accusation that they're making about that statement is completely out of context. And I certainly was going to try to give the question and answer I gave, as opposed to just that single bubble by itself, because that was not part of the way that treatment and that testimony should go.
And I got the feeling that there was a little more.
No, that's not the way that testimony should go. Unfortunately, it did go that way for you. And why are you talking to the press if you're still under subpoena? Is he still under subpoena? Could somebody remind me? Because maybe that's why the reporter showed up at the courthouse today to tell the judge, hey, by the way, Tommy Benefield, cousin Tommy, is still under subpoena. And he went on Court TV last night. And shouldn't Court TV know better than to call him on TV? I'm a creep. I'm a weirdo. The hell am I doing here? If we were going to, and you know what? I thought that Creep would be a great song for our playlist if we were going to do a playlist for this trial, but I'm taking that back a sentence or two.
They're making about that statement is completely out of context. And I certainly was going to try to give the question and answer I gave, as opposed to just that single bubble by itself, because that was not part of the way that treatment and that testimony should go.
And I got the feeling that there was a little more to it, and it's about context, but obviously we know what he's attempting to do and what's happening. So this trial is moving very quickly. Are you guys and your family and everyone else that's down there, you guys staying till the end here?
We'll be all here all the way through. Benny, there's one very, very interesting thing that happened today that was outside of anything we had known previously. And certainly the testimony of the deputies and the folks who came on the scene at the Ashley and Alicia's home where Doug was killed. The fact that the gun turned out to be, we'll call it jammed for the sake of that. But we always wondered why Ashley did not shoot all the bullets out of the gun. We found out today that after 4 shots into the 5th shot, the gun jammed. That was new information today.
Yeah, you know what can cause that? You know what can cause it to jam? A struggle. A struggle can cause it to jam because you know what? A gun expert emailed me yesterday and told me that. I'm going to look for that email because it's here somewhere. But the fact that the way specifically that it jammed is indicative of a struggle, Tommy. So you may want to take a step back just a little bit.
We had not ever had before. Very, very interesting that when the police picked up the gun from the neighbor next door and from Ashley, it was still jammed.
And before we go tonight, are there, for Eva, I know that she can't talk to you because she's still under subpoena, but your thoughts about her tonight being in the courtroom, being there with Ashley. She's now allowed to at least watch the rest of the trial from the gallery, but she can't talk about it, obviously. But your thoughts about her tonight?
Eva has been very courageous throughout this. She's very outspoken with her influencing on TikTok, and in particular about her recovering from the trauma of losing her father after losing her mother previously. I think she handled it very, very well today. And we were very happy that the state prosecutor invoked Marcy's law, which is the law where the next of kin can be in the room. So while she is a witness and she has not been released from that subpoena, she's in the courtroom getting to hear the testimony as Doug's next of kin. We were very, very thankful for that. She's been very courageous, and she's just telling the truth about what she saw.
All right, Tommy Benefield, Doug's cousin, family spokesperson, first witness in the trial. Thank you so much for joining us tonight. We really appreciate it.
Thanks, Vinny, for continuing to cover this fairly.
When we come back, we'll bring in our think tank. We'll talk about the 9.
I can't watch I can't watch the think tank. I can't even imagine who's in it because the think tanks of late have not been anything that I want to participate in. Let me show this. This is the interview with Stephanie Murphy. And so when was this actually? Let's see. Hang on. All right. Well, apparently Stephanie Murphy gave also an interview to Vinnie Politan. I'm not sure when this one was, but let's see. Take a peek at this. You know, we're here. Why not? This was posted on the 18th. What's today?
Doug and Renee Benefield lived in Mount Pleasant, South Carolina with their teenage daughter, Eva. In December of 2015,
I just want to fast forward it to the Stephanie Murphy part. Oh, wow. Tommy and Stephanie Murphy together? This is interesting.
What was your understanding of what was happening?
Hold on. Okay.
Of this murder case. Joining me, Doug Benefield's cousin and family spokesperson, Tommy Benefield, and Doug Benefield's former attorney, Stephanie Murphy. Thank you both for being here. Stephanie, I'll begin with you. I'm trying to understand the status of things. Was this a divorce case? Was this a custody case? What exactly was this at the time of the shooting? What was going on? What was the purpose of the evaluations? And from your perspective, what was your understanding of what was happening with this couple?
So the divorce case was still pending. In fact, we had a hearing scheduled the week after Ashley ended up murdering Doug. But the hearing was technically scheduled to be in an injunction case that Ashley had filed earlier that year. Once again, her injunction had been denied, but a hearing was set and continued several times at her request so that we could attend mediation, which was done 3 days before the murder. The murder happened on the Sunday, and then we were scheduled to be in court on that next Wednesday. The purpose of the hearing on Wednesday was to address the joint motion to release.
I don't think this is from today, you guys. This was posted on July 18th. So this, I think, was pre-trial, I think. Yeah, it's an old interview. Okay, so just let's take a listen.
Dr. BROEDER's psychological reports.
So that's when everyone would find out what the intentions or the intentions of Ashley were to not be with Doug. Tommy, at this point, is your cousin under the impression that he's getting back together with Ashley and the family's going to live together in Maryland?
Yes, sir. And
Objection.
not only
Objection. You can't testify to that because you don't even know anything. You talk to him like twice a year, dude.
his impression, but Ashley and Doug, when they picked up this 26-foot U-Haul truck on Saturday, Ashley told the manager, because I spoke to him personally, about the fact they were putting their family back together. They were moving to Maryland. They had already filled up a pod of all of the Ashley and her mother's a lot of their house goods. And Doug had filled up the truck with all of his stuff. He had brought the truck over there that night. On Sunday, he called me before he brought the truck over, and he called me and said that he had found out on Sunday that Ashley was not going to have Doug move in with Alicia, Ashley's mother, Ashley and their daughter in Maryland. This was, I think, the third time in not only the house in Lakewood Ranch where he's killed. He moved in there and then never.
I can't even listen to this because he's just spewing lies. None of this is true. He didn't testify to any of this. He didn't move in with her in Florida, did he? Or did he?
Got to move in. They got an apartment together on paper. She never moved in. And this was the third time that he thought they were going to move in together. That's what she told other people.
Exactly. It's not the full story. This can influence people so much. And this is aired before the trial. I want to see what what she has to say about it.
And the mediator had an exchange of emails explaining that the intention of the mediation was just to get a report.
I can't, I'm not, you guys, I can't do it. I can't do it because none of this stuff came in. It was highly inflammatory, prejudicial, and not accurate. So I won't even do you guys the disservice of playing it. So there's that. Thank you, Robin. There wasn't any testimony that Doug and Ashley were going to live together, and Doug and Ashley never lived together in Florida. Thank you, Robin. Thank you for spewing truth. And this is why people out there have this public perception, just guilty, 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 guilty. Thank you, Melanie, so much for the 20. I'm looking at 70, and I can tell you those older women may hang this jury. That's interesting, Mel. Why you say that? Sarah and Shock and Horror gifted 10 memberships. Thank you so much, Sarah. You're the greatest. So generous. Reality Check. Thank you so much. That is exactly, that came from you, Reality Check. And we played that first one with cousin Twami. Lone Pony, thanks for becoming a member. Reality Check, please check. That's it. And Murphy and the brother, the cousin. If you guys want to go watch that, go ahead, look for it. That's on the Court TV website. It's called What Was the Status of the Family Court Case? But I just, in good conscience, I cannot play that. Katie, thank you so much for your $10 super sticker. I appreciate you so much. Jennifer, thank you for the deuce. And Jennifer Robinson, I can't figure out how to become a member. Did we ever resolve that issue? I don't know. Try and look when you are done. You can look underneath. There should be a join button. And if you can't find that on your iPhone, sometimes it's a little bit tricky. Thank you, Iceman 2.0 says, unfortunately, what people are missing is that if Ashley didn't defend herself, it would be Doug on trial today, and the world would be the lesser with two less strong women in it. See that? Thank you. Thanks, Iceman, for spreading truth, and Shelly for becoming a member, and some anonymous benefactor who sent me 3 matcha lattes. I appreciate you so much. and all of you out there who are always so kind and generous to this channel. It's been a long day, my friends. If you didn't watch the morning stream, go and watch it because we've had quite a full day of testimony. And in my opinion, oh, thank you. Thank you, Melanie, for the Cash App. Another Melanie. There's a lot of Melanies in the chats as well, in this chat, I feel like. A lot of crazy testimony today. I've not seen anything that makes this a slam dunk for the prosecution, but guide your actions accordingly if you choose to go watch the commentary today on other channels, the chat. You might want to turn off the chat or watch it just so you know what's going on out there because people are crazy. People are crazy. Everyone thinks she's guilty out there, apparently, except for this chat who seems to know better. And I'm mystified, horrified, I'm in shock and horror. But here's what we're going to do. We're going to come back in the morning. Thank you, Athena, for jumping in here at the last minute 10. We have a plant in the Carolinas that Doug could have used to cause both cause a heart attack in wife one and poison Ashley in her tea. I won't name it. I'm very suspicious. Attorney here. Hi, Athena. Counselor. That's interesting. Does it make things taste sweet? Because she did say that her tea tasted sweet. Nobody believed her. Sinbad, thanks, says Tommy was released from his subpoena, I think. Seems so many were, and I'm flummoxed now. I'm going to go back and watch his testimony, and I'm going to find out for you. Sherry, thanks for becoming a member. I'll see you guys all tomorrow morning. So don't worry, you won't have to miss me and each other for too long. Thank you, moderators, for keeping the chat classy. Scott, I'm going to try and fix your wrench. I don't know what we can do to do that, but we're going to try. And to everyone here, thank you for coming. Hit the like button on your way out. Let your friends know that this is a safe place to watch this coverage. And yeah, I think you think I'm going harder for the defense than most. I haven't seen anything that's proving to me that this is not a self-defense case, but I'm seeing a lot of skepticism whether state is making its case. Yeah, I don't know. We have a lot of survivors in this chat, a lot of them, and they've told us their stories and they've told us, you can't judge how a person behaves in a situation such as this. Not everybody behaves the same way. And seeing all the misinformation that came out before the trial started is just giving people pause. Can't see how prosecution and jury find doctors' testimony damaging. So far, I don't see any of these defense witnesses who are making this a slam dunk. So one a-hole of a detective get on the stand today, and he was, I think, really harmful to the defense. But, other people are going to spin it other ways. And as I say, as always, my friends, I will see you in the morning. Make sure you have notifications set and subscribe. And, just be cool, be kind, be classy. It's not hard. It's so not hard. Why does everyone have such a hard time out there, except for you guys? Love you. Peace out. We'll see you in the morning. Thanks for coming. Have a great evening.